who are here early, you will get a special prize. Today is February 5th, 2026. We're going to begin our bill hearings for the House Judiciary Committee. Our first two bills are departmental bills. We're going to start with House Bill 281. And whoever's here for House Bill 281, feel free to come forward if you have favorable testimony. James Torres. Is that James Torres? No? Okay. Well, the department is here, so you may begin.
Is it on? Yeah, this is on.
This one. Okay. Okay. I can't see you. Can't see you with my glasses on. Good morning, Madam Chair, Madam Vice Chair, and members of the Judiciary Committee. I am Catherine Call. I am the Deputy Director of Government Affairs for the Department of Public Safety and Correctional Services. And with me today is Alec Whedon. He is the Director of Policy Management with our Information Technology and Communications Division, and he is also Maryland's FBI's Compact Officer. I am here today in support of House Bill 281, an essential departmental bill that ensures that the state continues to access national background checks for individuals who care for and supervise children. You have the department's written testimony, so I will simply stress the importance of this bill. The department has been in discussion with the FBI since the passage of legislation in 2023 in an effort to receive approval of language that will keep Maryland in compliance with federal requirements. This year's bill simply makes clarifying changes expressed by the FBI to explicitly state that only designated governmental agencies can receive a national background check, and that private entities receive a state-only background check. Due to our good faith efforts to update the law to ensure compliance, the FBI placed Maryland on a grace period just to the end of this year for the use of codes required to conduct child care background checks. If these changes are not made, the department will not be able to conduct national background checks, as our status as a user will not be extended. We do have an amendment that I will provide to committee staff. It adds the names of the state departments under their appropriate sections, which was just mistakenly left off during the bill drafting process. Thank you for your time, and I urge a favorable report on House Bill 281.
Or just here for
He's
questions?
here for questions.
Okay,
yes.
great. And your name, sir?
Alec Whedon.
Nice to meet you. Are there any questions for this panel? I have one. So the department, in anticipation of the federal requirement, is seeking this change. Is that correct?
Yes.
And will there be a loss of funding if this change is not met?
No, it would be an operational change where the national background checks for child care purposes range from MSDE, MDH, youth camps, things like that, daycares, family child home care agencies, foster care. Those numbers, those codes that are used for those background checks will be shut off.
Okay, so we will not be able to determine within those areas whether or not someone has committed a crime outside of the state of Maryland.
Correct.
Correct.
And so in anticipation of that, that's why you're presenting this bill.
Yes.
Okay, thank you. We're going to move on to the next panel. Thank you.
Thank you.
Favorable with amendment. Ellie Colmers. All righty.
Hey.
Hi there. Alec Whedon, Jr. Oh, I'm sorry. There we go. And Catherine Call? And that was you. Okay. You all,
Just me.
okay. It's all, okay. It's all fine. We're going to have a good day.
Yeah.
All right, whenever you're ready.
Okay, great. For the record, my name's Ellie Colmers Cowan. I'm here on behalf of SEIU Local 500 and the Maryland State Child Care Association to offer testimony for favorable with amendments. While I understand the need to bring the state into compliance with the federal requirements, and safety is always paramount when particularly when you're talking about our most vulnerable populations like children. However, we are concerned that there could be unintended consequences in financial burdens on the child care providers, as well as a delay in onboarding for a field that's already facing extreme workforce shortages. So in the fiscal note, you'll see at the very end, it does, DLS notes that the bill has a meaningful impact on small businesses, particularly child care providers. So we would just ask that as you're considering the bill, to ensure that there's no unintended financial burdens on our child care providers. Thank you.
Thank you. Members waiting questions? Seeing none, that concludes the testimony and bill hearing for House Bill 281. We're going to move on to our next bill, which is a departmental bill, House Bill 282. Do we have Greg Sessick? Yes, and Alger Studstill?
Yes,
Jr.
ma'am.
Okay. Great. Whenever you're ready, sir. Thank you.
No problem. Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. I'm Dr. Alger Studstill Jr., and I serve as the Executive Director of the Social Services Administration within the Department of Human Services. I'm joined by my colleague, Greg Sessick, who serves as the Deputy Executive Director of Adult Services, who will assist in answering any questions that you may have. We respectfully urge your favorable report of HB 282. We are driven by 12 Moore Miller administration values and believe this bill exemplifies these values. HB 282 asks us to be responsive in prioritizing the safety, well-being, and independence of adults who are served under the Adult Protective Services Program here in Maryland. HB 282 acts with urgency to align state statute with federal law in key areas. The federal rule for APS sets minimum standards for states to deliver excellent service consistently across the country. In state fiscal year 2025, APS received 22,802 reports from the community regarding safety and well-being of adults in Maryland. This represents a 217% increase from 2018, in which APS received 7,100 reports. APS workers are first responders who quickly identify whether our loved ones, as well as Marylanders with no family or social support, have the services they need to live safely in settings of their choice. We respond to reports in family homes in the community, as well as long-term care settings such as assisted living and nursing facilities. In May of 2024, under the Biden administration, states' APS programs were federally organized under the first federal rule for APS. Prior to the Federal Administration for Community Living publishing an adult protection rule, there was no nationwide adult protection framework or funding. In Maryland, our APS program already meets or exceeds a majority of the requirements of the 2024 federal rule, although a few areas require our attention. Our bill adds psychological harm and sexual abuse as APS investigatory responsibilities. It also creates a more concise definition of exploitation, where harm is caused when a relationship of trust is breached by someone who has assumed responsibility for the care and protection of a vulnerable adult. We appreciate the opportunity to provide testimony and urge a favorable report and welcome your questions.
Are you here for questions only? Okay, great. I have a question. I'm looking at testimony from people on the go, and they have concern about, and they said serious concerns about provisions that may inadvertently harm people with intellectual and developmental disabilities and undermine their fundamental civil right. Can you address that?
Was any context provided as?
Oh, yes, there
how?
was. There was context provided. I just took what I needed when I was reviewing it. Hold on one second. In relationship to trust of Yeah, hold on. I'll give you more, just give me 1 second here. So they are concerned with respect to section, they want to amend section 14-304. If I'm in the right section? Yes, I am. Okay. So they were concerned about, let's start from the beginning. So removal of relationship of trust limitation. They want to strike the requirement that abuse, neglect, and exploitation can only be committed by, and replace the language that protects vulnerable and valuable adults from harm by any person or entity. Does that help you in any way?
I'm trying to follow what they're striking.
Okay, I tell you what, I don't want to take up the time of the committee, but I will, I found it. It's on page 2, section I, and it states, indicated, quotes, means of finding that it is more likely than not that the individual is a vulnerable adult. Abuse, neglect, self-neglect, or exploitation has occurred. No, that's not the section. I apologize.
Madam Chair, if it would be helpful if the department receives a copy of the testimony, we can review
We
it
can
and
provide that, and if you could provide a response, that
Yes,
would be
ma'am.
perfect. Thank you very much. Any other questions, members? Okay, great. Oh, Delegate McComas.
I just have one brief question, and I guess my concern is at the end, I think you change it that, in other words, before it was 10 days, you have to have, and now there's no timeline. Well, 60 days, and I think 60 days may be a little too long if it's an emergency situation or it's an imminent. So I was wondering if there's some, I don't expect you to have the whole thing nailed down, but, if somebody's being abused, something needs to happen that they're protected, before the full investigation. So is there a way you could draft that to make sure that people are protected?
Yes, ma'am. So what I'll say is that's just the 60 days notes for when the investigation must be completed. However, from day one, when we start working, we're partnering with law enforcement or other entities. And so if a family or a vulnerable adult is in need of services, they receive those before day 60. This is just saying that the case has to be closed within the 60 days. The limitations of why we remove the 10 days is especially when we're working with sexual abuse and financial exploitation, those investigations take longer when you're working with medical examiners, physicians, as well as law enforcement. But we don't wait until a case is closed to serve the vulnerable adult.
And that's already somewhere in statute.
It's a part of our policy.
Great. And Delegate Embry.
Thank you. I'm sorry. And again, this is following up on the chair's questions, but there's two aspects of the bill that seem to constrain the agencies, limit what is already happening. One is what the chair said, which instead of any person harming, now you're only concerned if there's this trust relationship. So I don't understand that. I would think we'd want all. And then just to follow up, the other constraint is you're adding, there has to be risk of harm for certain things to happen, but it would seem that if there's abuse of a vulnerable adult, you would still want some of those next steps to be taken, even if there's not a risk of harm. So those were two things that seem to limit the protections that already exist that I didn't understand and I think are contained in what the chair referred to.
And I'll let my colleague jump in if I missed anything. I will say when we, in regards to the adding the individual with a relationship of trust to the vulnerable adult, it is redefining the scope of adult protection and how we're working with those cases. So if someone falls outside of that particular category, then our partners in law enforcement would be handling that as a criminal investigation. But when we look at the scope of authority for an adult protective services program, it's looking at the individual that has some relationship to the vulnerable adult. Similar to on the child side, we don't investigate everything. It's only when it's a parent, guardian, or someone who has a relationship with the child that gives us that scope of authority as a child protection or adult protection system. Anything?
Thank you.
Thank you. And we're in the process of sharing that file with you, so you'll probably have it when you get back to your office.
Yes, ma'am. Thank
Okay,
you.
thank you. Ladies and gentlemen, we're gonna go ahead and skip just a little bit because delegates or the bill sponsors are not readily available at the moment because of other commitments. We're going to skip down to House Bill 389.
I was here to testify on that bill.
And I'm so glad you said something. Thank you very much. Please come forward. Ms. Valerie Borick?
Yeah.
Okay. This is our unfavorable testimony
Sorry.
on House Bill 282.
Thank you. I didn't mean to interrupt your proceedings, but I didn't.
No,
I
you
came
did the
here for
right
this.
thing. Thank you very much.
Thank you very much for the time. Valerie Farrell from Cecil County, and I am here for opposition to the bill just because I want Maryland to act with an abundance of caution regarding the potential effects on caregivers and on our Maryland budget. When I testified in the Senate on this same bill, the sponsors approached me after and we had great conversations, so we're all on the same page that we want to protect vulnerable adults and caregivers alike. But here's my context, is my sister has a disabling brain injury and psychosis. Our parents are deceased, and so I took her into my home for over 5 years. She was waitlisted for psych housing for over a year and sadly became increasingly violent to the point of attempting to stab me. So then she ended up in the detention center for 9 months and finally, praise the Lord, was accepted into a psych residential program just this month. But I just want to point out, APS does very important work. They sort through all of the mandated reports of potential abuse or neglect of vulnerable adults. And as a caregiver for someone with psychosis, I and my husband have undergone these investigations initiated by mandated reporters acting in abundance of caution there. So I just have to put my concerns on the record about narrowing, it's already been said, the narrowing the any person in the statute to a person with a trusted relationship. And I wanted to ask, does this bill need amendments to clarify that assuming care, which I did, which I had no legal obligation to do, does it create a legal relationship with this language? And do we need to also clarify that the family trusted relationship must be active and tangible rather than remote? Because at this point, my sister is no longer under my care, and I wouldn't want to have yet another mandated reporter act in an abundance of caution and kind of have to undergo that process again. Second, I have pause about adding the psychological harm to the APS scope of investigations because it's already abuse under the statute. And reporters, given a new category to screen, would err towards more reports. Are we really missing the malicious psychological harm in our current screenings? And finally, Maryland isn't required to follow federal government's guidelines, of course. There's no federal funding attached to these changes, and so I don't want the burden to also be put onto Maryland and the counties.
Thank you very much. Members, do we have any questions? Seeing none, thank you for your testimony.
Thank you very much.
That concludes our testimony for House Bill 282. And now I'm going to move to House Bill 389. I'm going to ask the Vice Chair to take over. How's everybody doing? Good. Good. Glad to hear it. Yes.
All right. Next on the agenda is HB 389 with Delegate Bartlett. I would like to call the names of those up front. Is Sarah Sample here? Thank you. Crystal Williams? No?
Oh, I'm here.
All right, I'm going to call the first five. Gordon Pack?
Yes.
Laura Wilt? Okay. Oh, those four? She raised her hand.
We're going to go out of order just a little bit because since everyone's seated.
Okay.
Yeah. But if you could give your name, please, so she.
Your name, sir?
James Dole.
Thank you. forgot Mr. Pat. Okay, you may proceed.
Thank you. Good afternoon, Vice Chair Davis and distinguished members of the House Judiciary Committee. I come before you today in support of House Bill 389 that would place limitations on juvenile contact with incarcerated adults. I refer to this as getting kids out of adult detention. The bill prohibits any child who has been arrested, convicted, or is awaiting trial, including those who are charged as adult, from being detained or confined in any facility in which the child has contact or comes within sight and sound of an incarcerated adult. This bill creates an exception that allows for a child to be temporarily held in a facility, but it's only for processing purposes, and even then, the child has to be separated by sight and sound. The bill codifies the requirements of the federal law, Juvenile Justice and Delinquency Protection Act, also known as, and you will hear referred as, JJDPA, which was reauthorized in 2018, and it establishes protections for juveniles in custody. Among other requirements, the JJDPA requires that children do not have any contact by sight or sound with inmates and may not be held in adult correctional facility for more than 6 hours, known as juveniles, the JCA requirement. The JJDPA provides formula funding, which you will hear about and you can read about in the testimony from the State Advisory Group, that states the funding is provided to states for the implementation of programs and services for youth. But for each requirement that a state does not meet, JJDPA reduces the state's funding by 20%. In January of this year, the Office of Juvenile Justice and Delinquency Protection issued notice to the state of Maryland. Now, mind you, the bill was enacted or reauthorized in 2018. All states were given 3 years to get into compliance. Maryland is not in compliance. We were not in compliance then. We are not in compliance now. You can do the math. The funding is going to be reduced. This is not an if, this is a definite. It will be reduced for the state of Maryland because we are out of compliance. So I bring to you this bill because this is not the first time that this issue has come up. In fact, it was the Department of Juvenile Services that brought this problem to our attention when they introduced the bill in 2022 and in 2023. And in fact, one year it was an emergency bill because the department was trying to argue that it needed to be in compliance with the federal law. And since then, I've been bringing the bill because we still are out of compliance and we need to be brought into compliance. So I ask you, members of the committee, when you hear testimony today, I want you to ask yourself, what is the plan? Is there a plan? What is the plan to get our kids out of adult detention? And if the plan is contingent on another bill, such as the auto charging bill, which I fully support, that's not good enough. Because the auto charging bill has been introduced for 14 years. And for 14 years, the auto charging bill has never come up for a vote. Now, it may come up for a vote this year because I am the bill sponsor, but I can't say what's gonna happen across the street. So, with that said, and knowing that we have been out of compliance since 2018, there were facilities that were closed. There were juvenile facilities that were closed in 2022, despite already being in violation of JJDPA at that time. And in fact, you're going to hear that one of the arguments is why the department cannot comply with JJDPA is because of lack of capacity. Well, we closed facilities in 2022. We have done nothing to change facilities, to correct facilities, to somehow make facilities better. I find all of that problematic personally. So with that said, and believe me, there's a lot more that I could say. And if anyone wants to know what other states are doing, I'll be more than happy to answer that question. But I am personally offended, and so should you, that Maryland is so you should be as well. Maryland is an outlier. We are not in compliance. We're not working to get in compliance. And we are housing juveniles with adults. And I'll tell, well, some of the other panel members will tell you what that looks like. But I will tell you what I saw with my own eyes. It's a screen being placed down when a child is walking by. Now that screen is not covering their ears, so they could be hearing anything that's being yelled out. And also, it's a resource problem because there is a child in their facility, and you will hear, because there is a child in the facility, that requires resources to wrap around that child, meaning other officers, to be in the presence of that child. And it also requires, more importantly and most importantly, and I will end my testimony with this, that that child is in restrictive housing, formerly known as solitary confinement, for 23 to 24 hours a day. This is pre-trial status, meaning guilt or innocence has not been determined, and this is how Maryland treats our children. Thank you very much for your consideration, and I urge a favorable vote.
Thank you. Who would you like to go first? Start from that?
Good.
We'll start from that side and we'll move over. Thank you.
Good afternoon or good morning. My name is Gordon Pack. I serve in a lot of different capacities and different commissions, but I'm here today to let you know that as a 16-year-old, I was adjudicated as an adult, and I spent time in an adult detention facility. Because I was smaller, because I wasn't seasoned, because I didn't come from the right neighborhood, I didn't have the connections with the different people that were there, I was subject to a lot of harm that it's taken me years to get over. I have been robbed. The first day I was in there, I was robbed. People have stolen my property. I've been beaten up. I was almost raped. I've been around other kids in this situation who got sexually assaulted repeatedly, and nobody was there to help them, and their only out was to set their cell on fire so they could get away. I know friends who started off co-defendants. One said, I'll take the weight so you can go home. Just tell the people this. The other people said, you can't have a snitch, gave him a knife, and he stabbed up his friend. So this is a real weird situation where kids go in and they come out a lot worse than they went in. I know people who went in, became leaders of gangs, who OD'd 20 years later and never had a drug problem. So I'm here to say this is a good move. This bill is a great move to try to protect children from coming back into the prison system. Thank you for your time. If you have any questions, I'll be glad to answer.
Thank you so much, Madam Chair. James Dole for the record, representing Human Rights for Kids. I just want to start by thanking the chair for introducing this bill. I'm also a proud constituent of the delegate out of Laurel, Maryland, so I'm very excited to be here with her today. I want to start my testimony by just talking a little bit about who these kids are. Approximately every single year in the state of Maryland, 1,000 children, almost all of them Black, are processed in adult jails. Right, since 2008, between 2018 and 2024, we're talking almost 5,000 children total. These children, we did a study a couple of years ago that we published of children charged as adults. What we found was that they were among the most vulnerable and victimized kids in our society. Over 70% had experienced both physical and emotional abuse prior to their system involvement. Over 45% were sexually abused. Most of these kids came from homes where one or both parents were absent, and in half of those cases, parental absence was due to parental incarceration. Right, so we take these already vulnerable and victimized kids and we place them in these adult settings. We ask those same group of people, what happened to you when you were a child placed in an adult facility? 75% of them told us that they experienced abuse at the hands of older adult prisoners. 88% were physically abused, 57% were emotionally abused or psychologically abused, and 15% were sexually abused. We are sending already vulnerable, victimized children into facilities to be further exploited, abused, and harmed. It is for that reason, as the chair noted, that these kids often are moved into solitary confinement for their own protection because it's the only place that these children can be safely housed. Now, I don't have images that I wanted to hold up, but I was going to show you pictures of Kaylin Drake, who died by suicide about 1.5 years ago down in Mississippi after she was placed at an adult detention center. The year before that, Joshua Beasley in Texas killed himself within 2 days of being placed in an adult facility. I'm telling you right now, it is not a question of if, it is a question of when. A child does the same thing here in the state of Maryland, and now another child is dead because this body and the powers that be haven't acted. We are asking you to prioritize this bill to make sure that no child here in the state of Maryland dies under the same tragic circumstances.
Thank you, Mr. Dole.
Based on that, we'd urge a favorable report. Thank you.
All right, thank you. Next.
All right, thank you to the committee for having me. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we are here to support Senate Bill 389. You've already heard a little bit about why adult facilities are not right for juveniles. I would like to share that I've been to about 9 facilities in the last 1.5 years, and the lack of compliance is not through a lack of effort. They're really jumping through some pretty courageous hoops to try to make sure that we can get in compliance. And we don't come to you guys lightly and tell you that we're out of compliance. But they really are trying. Sometimes they can get close on the site stuff, but the sound, that's a really, really difficult element for us to try and hit. Another effort they're making is trying to transfer individuals to other facilities that are a little bit closer to compliance. And then you've already heard that sometimes within a facility, if you can't transfer them or can't get the separation done, that they're ending up isolated. And that is an inadvertent consequence of this being pretty much impossible in our facilities. As far as some of the things we've heard from the state in the past, you know, the thing that keeps coming up is that they don't have enough space, they don't have enough capacity. And I can share with you that between MACO and all of the counties, we are really starting to lose our patience with the state when they're saying that they don't have enough space for certain individuals that are detained. Particularly, a good example of this is when it comes to the mental health transfer backlog. These are individuals that are supposed to be in the care of the state that end up with us for hundreds of days sometimes. And this is hundreds of individuals. So we really need the state to step up and help out somewhere. And that mental health transfer backlog, that's one of like 5 things that the state is out of compliance on. So we really just beg, we need the state to jump in and help out on something, and which is why we would really urge a favorable report on House Bill 389. Thank you.
Thank you. Next.
Thank you. Good afternoon, members of the committee, and thank you, Delegate Bartlett, for having us here to testify today on this very important bill. My name is Crystal Williams. I'm an attorney with the Maryland Office of the Public Defender, and I work in the Government Relations Division as well as the Mental Health Division. But I've also represented children who are charged as adult in Baltimore City for several years. And what I can tell you is that it is important that we pass this piece of legislation. It is important not only to ensure compliance with federal law, which we are wholly out of compliance with, but more importantly, we need to protect Maryland's children. And when it comes to charging children as adults, as long as we uphold this practice, compliance with federal law and the standards of humanity in protecting children will be a perpetual issue. All children who are charged as adults in Maryland are immediately placed in an adult facility. That is something that most people do not understand when we look at, we have a statute that there is a presumption to move a child to a DJS facility upon their arrest. But they are all booked and processed through adult facilities, Baltimore City and every county across the state of Maryland. What happens after that is actually dependent upon where they are and what jurisdiction they are. And if a judge does in fact grant that motion for them to move, if a judge does grant that motion for them to move their physical body to a JJS facility, every jurisdiction doesn't have the capacity or the availability. So 2 children could be charged with the same offense across the state of Maryland, and depending upon capacity or facility constraints, one can end up in solitary confinement, one can end up in a cell with other adults, and one can end up in a DJS facility. That is simply unacceptable. We need to have the same standard across the entire state of Maryland. We also need to make sure that these children never have contact with adults, whether it's through the adult booking process or whether they're awaiting their actual transfer proceeding. And so for those reasons, we ask for a favorable report on this bill. Thank you.
Thank you. Are there any questions? Yes. Delegate Arakan.
Thank you, Madam Chair. Madam Chair, I did want to ask you what other states are doing, and also if you have can you just remind us again what the actual loss and funding is that we're looking at, so we can conceptualize that?
Thank you. So if you, well, I'll just put it this way. The best way to explain the actual loss is to look at the state advisory group's testimony, in which they state that it will be over a 3-year period of time, $2 million.
Okay.
And with respect to the states, some of the states that already have laws banning children from being detained in adult facilities and are California, Colorado, Delaware, District of Columbia, Georgia, Kentucky, Massachusetts, with an exception of allegations for first and second degree murder, New Jersey, New Mexico, New York, North Carolina, North Dakota, Washington, and Virginia also have post-conviction prohibitions. So even after a child has been convicted, they still cannot be housed with an adult. Ohio, Oregon, Vermont, with an exception for felony charges. And West Virginia, thank you. And in 2021, Hawaii has post-conviction. Indiana, Ohio, Oklahoma, Utah. Utah has post-conviction as well.
Wow, okay,
Yeah,
so
so the
not just liberal bastions.
Right,
No,
right.
this is everybody.
Yes,
Almost
yes.
everybody except us.
You got it.
Interesting. Okay, thank you very much.
Thank you. Yes. Could you just add?
Just one quick point of emphasis too. President Trump in 2018 signed the reauthorization of the JGDPA into law. That law actually put in place stronger protections. So the Trump administration and Senator Grassley, who championed that bill, actually was the one that put in place a requirement that we need sight and sound separation and kids can't be held longer than 6 hours. That's the thing that pushed Maryland out of compliance. So the reason we just got that letter from DOJ was because of the law that President Trump signed into law into 2018.
Thank you. Delegate Valentine.
Thank you, Madam Vice Chair. And thank you, Madam Chair and the panel. I have a question about, hopefully you can explain this to me. Under the adult correctional facility in general, I'm trying to think, I think of 2 jurisdictions specifically that have a juvenile, I don't want to call them a holding facility, but that's kind of what they are, or are planning to, or were planning to. For those individuals that get placed by DJS, but they can't be transported within the 6 hours, they're separate sight and sound, and they would be under the roof of the correctional facility, but they're in a separate wing of that facility for that 18, 24, 36 hours, because in the far reaches of the state, they can't get to a more permanent location. That first, say it's on a Friday in their place, and they can't be picked up till Monday to get, or a day or two. And I had a couple of inquiries about that specifically because of the situation of where that's located, because it's technically within the 4 walls of the detention center. How would this impact those individuals?
Well, I think, quite frankly, if that were the only problem that we were having in the state of Maryland, that would be okay. If they were trying to make the transport and they couldn't make the transport in time, then, you know, that would be better than where we are now. So it's not that I'm not open to any amendments to this bill. I just want the final result to be that kids are not being incarcerated with adults intentionally. And I say intentionally, not because anyone's mean or anything, but intentionally because that's what we do.
And can I follow up?
Yes, yes.
And I thank you for that. And I would love to talk to you offline about that, about one specific example, because it would simply be a 2 or 3 bed unit just for that particular moment in time to get them transferred to another location, and kind of describe it to you in more detail.
And that would, I think.
The intent is not to hold them there.
Yeah, I think that makes sense, Delegate Val. I appreciate that. I think that makes sense.
Thank you. Thank you, Madam Chair.
Sure. Delegate Cardin?
Hey, Madam Chair. Thank you, Madam Chair, for bringing the bill. It's just a question for you or Ms. Sample. We in Baltimore County have had some issues that we're actually improving on slowly. But one of the issues that has come up is that when a juvenile is put into the detention center, there's no location for them, so they're put in solitary confinement. Can you just highlight what concerns that raises if you are, in order to obey the law, you're putting a child in solitary confinement for an extended period?
I'm going to ask Mr. Dole, because their report that Human Rights for Kids did really addressed some of the adverse situations that happen.
Yeah, absolutely. James Dole for the record. So just to be clear, when we're talking about solitary confinement, it is recognized as a form of torture under international human rights standards. The UN Convention on the Rights of the Child categorically prohibits its practice, and groups that work with children, doctors, pediatricians, have also come out against its practice. And part of the reason for that is there's all sorts of harm that befalls children. What we know from this population is that they're also very highly likelihood that they have disabilities already, mental health problems that they're dealing with, and when you place a kid like that in isolation, it just exacerbates those problems. When we're talking about 23 in one lockdown, we're also talking about kids who have problems get the proper dietary nutrition, they're not getting proper exercise, so there's actually a physical harm that can befall these children as well. One of the things that we didn't touch on, and for many folks in the committee, I think I met with you before this hearing, there's a great NPR article that I highlighted where it kind of shows the length of time that we're talking about for some of these kids in these facilities. Sometimes it's weeks, but we've seen that kids have been held in adult facilities for years, right? And then that same survey that we did when we asked people, what was the longest stay that you had as a child in solitary confinement? 20 months was the longest average stay that people indicated. So we're talking about kids who are in isolation. They're scared. They're going through mental health crises. That's why I highlighted at the beginning that kids placed in adult facilities are 36 times more likely to commit suicide than kids in juvenile detention facilities, because it exacerbates those mental health problems. It hurts all of, it's all of those sort of issues. So it's incredibly harmful to children. And again, it's torture.
And we've heard this testimony before, and thank you very much for re-enlightening us. Baltimore County has been doing better, so I just want to make sure we don't have the 220-day issue, but we do have maybe a day or two or three, and we still need to stop that, even if it's for the short period of time. So thank you.
And the only other thing that I would add to that is just based on what you just heard described from a county perspective, obviously that's a really big liability issue for us.
All right, thank you. Delegate Boucher.
Thank you, Madam Vice Chairman. And Madam Chairman, bless you for bringing this bill forward. As someone who is charged as an adult, there's nothing hyperbolic about the statements about the threats of rape. As soon as I was placed in the paddy wagon being arrested, I was threatened with rape right out of the gate. So thank you for bringing this issue forward. What I want to know, is there any data showing a reduction in the recidivism rate of juveniles not being cohabitated and incarcerated with adults when they move into adulthood? That is what we're concerned about. Is this a worthwhile investment on the long term to reduce the recidivism rate of these juveniles turned into adults? Is there data on this?
There is definitely data, and if you wanted to answer that, and I'm referring to Mr. Dole because that's what his company does.
Thank you very much.
Yeah, and I don't have the studies off the top of my head, but I can send them over in a follow-up. But the studies absolutely show that the more you put kids around older adult, seasoned criminals, for lack of a better word, the more likely they are to recidivate, which is why we emphasize so much in keeping kids away from older adult prisoners and keeping them in the juvenile justice system as much as possible.
So it's not a far stretch imagination to say that adult criminals are mentoring the juveniles to become adult criminals as well.
Absolutely, and as Mr. Pack also referred to in his testimony, these guys are exploiting them. They're preying on these kids who come in because these kids are scared. They're looking for protection, right? And so you have these older adult gang leaders who see this new kid come in, they can offer them protection. Hey, you go do X, Y, and Z for me, I'll take care of you. It's an absolutely horrific situation that we're putting these kids in. And so to your point, it absolutely is a benefit to reducing recidivism and making sure that those kids don't come back into the system if we're keeping them separate from adults.
Thank you very much.
Thank you. Delegate McComas.
Thank you, Madam Vice Chair. Real quick question. Maryland's been dealing with this similar issue for years and years and years, okay? My question is, all right, you don't want them in adult prisons because that's not the right place. They're not even convicted, okay? Why can't we have like special wings or whatever that the kids could go in a juvenile system, pre-trial, pre-whatever, and they would have the benefit of, they would have the counselors that are, deal with juveniles. There's the staff there that they're obviously their main job is the kids that have been found culpable, juvenile delinquents, but you've got the training, and you're not going to have that many kids that are going to, be in one juvenile facility. It might be one or two or three, and you don't have to worry about keeping sight, sound out of them, or these even being near it. And the kids can be more like kids. I just think, take advantage of what you've already got and build on smaller stuff next to it that keeps them away from the kids that have been convicted, but they're in a more safer environment, and you still got the experts. I'm just trying to think practically, because Maryland has had great plans for dealing with juvenile justice for years. In fact, we had Zirkin, Tony O'Donnell, and I can't think, Carmen Amadori. They all went to Missouri, and they looked at the Missouri model, and they thought it was wonderful. And then nothing happened. So if this was so wonderful, and I mean, it all comes to the money, but I just don't understand why we can't figure out a way to fix this.
Well, I agree with you, Delegate, and if you notice on the bill, if you all take a look at the bill, the implementation of the bill is 2028. So it is not immediate. And the reason for that is because we want to give the department time to be able to perhaps be creative and come up with some of these ideas that have been put out there. Perhaps to maybe think about the Missouri model. But that's the whole point of the delayed implementation of the bill.
I'm not concerned about the delayed implementation because it's been
it's been very delayed. You're right. Yes, you're right.
So
you're right.
I just think this is sad.
Yes.
We just can't seem to get off the dime. And then if we are causing kids to be suicidal or to be members of gangs, that's a bigger societal problem.
Thank you, Delegate.
Thank you. Delegate Phillips.
Thank you, Madam Chair and Madam Chair. This is one of those issues that we've been dealing with, struggling with in the Juvenile Justice Reform Commission and best practices. And to Delegate Arakon's point, we're an outlier. Can you talk about the fact that we're such an outlier that we're not even included in the federal numbers? You may have mentioned that. And where do we sit with all of this as it relates to our peers? And has there been any conversation with the Secretary of the Department of Juvenile Services about what their plans are to help fix this?
Okay, so I'll try to remember. I wasn't taking notes, but I'll try to remember each question. Let's start at the end. Yes, there have been conversations with the department, and we do have a brand new acting secretary for Department of Juvenile Services. I have met with her, and we have discussed this. We will continue to discuss, and if there's a need for us to come to the middle, then by all means, I am amenable to that. And it's not that she doesn't want to implement this, I have to say. It's not that the department doesn't, I'll say it's not that she doesn't want to implement this. With that said, though, we, as the General Assembly, one of our jobs is oversight and accountability. And we have to sometimes push agencies to do the work that the people we represent are demanding. And this is one of those issues that the people I represent are demanding. And so, while it's something that has been around, as Delegate McComas said, it's something that's been around for a long time. We need to hear plans, resolution, and start moving things forward. And that's what the hope of this bill and those conversations with the Secretary will lead to. You also asked about about Maryland being an outlier, and I don't know if anyone from the State Advisory Group is coming, but I will say that they have provided the testimony because the State Advisory Group actually goes out and records whether centers are in compliance or not. And they work with centers if they, if they have questions or anything of that sort to try to, get them in compliance. Also, I will state that portion of the money has to be, thank you, a portion of the money has to be used to get us in compliance. So the federal government is even saying, here, we'll help you get in compliance, right? And so we have that as well. And I was just handed this section right here, which I will state for you. Maryland is significantly out of compliance with federal standards, which we've talked about. And in 2025, OJDP began enforcing those thresholds on length of stay and sight and sound separation in adult facilities using new formulas. In FY 2023, Maryland's detention rate was 93.26 per 100,000 children, over 6 times the federal standard of 14.68. That number rose to 119.59 in fiscal year 24, a 27% increase. So we're not even, okay? So the state reported roughly 1,600 violations, more than any state, prompting OJDP to exclude Maryland's data from national averages due to its extreme outlier status. Yeah, it's embarrassing.
And how much did we lose? Money, real money?
We haven't lost it yet. We're going to lose $2 million in 3 years if we're not in compliance. Over 3 years. And we have a deficit, so that could come in handy.
See, no further questions. I have one question. I respect the fact that the bill allows for an extra 2 years to comply, for agencies to comply. But what happens when they don't? Does the bill address that?
Madam Vice Chair, that's a very good question. And whether I am here in office or not, I will be back if they're not in compliance. And I will be urging whoever is here to put in a new bill to somehow work with the department. Also, our Public Safety Subcommittee of Appropriations has incentive measures for agencies who are out of compliance and who are not getting in compliance. Perhaps there are some budget mechanisms that can be in effect. But unfortunately, that is part of the problem. Fortunately, we are here today and we're trying to do something about it.
All right, thank you.
I can also share that with how this has been dealt with MDH in terms of being out of compliance on the mental health transfer piece, is that the agency ends up in court nonstop. And then it starts to see that those resources just from the agency just get drained in court fees. So, and judgments that they have to pay out because they're in contempt of court. So that's the consequence ultimately, or one of them.
Individual litigants?
No, so the Maryland Department of Health with the mental health transfer backlog, because they're not bringing the individuals into the state hospital facilities, they're being sued and they're being held in contempt of court because they're out of compliance on it.
Okay, so, yeah, she was.
All right, thank you.
Yeah.
This concludes the first panel. There's only one other favorable person. I'd like to call Laura Wilt.
Hi, Thank you. I'm Laura Wilt with the Maryland Crime Victims Resource Center. I'm the senior attorney assigned in the Baltimore City region. You have previously seen me as the 28-year veteran of the State's Attorney's Office of Frederick County handling juvenile matters. So I am here on behalf of Maryland crime victims today, but bringing that experience. I also bring the experience of sitting on the state advisory group that our lovely chair was just talking about. So I've been aware of these violations for years being on that state advisory group. I am here today on behalf of victims to tell you that this is the bill that needs to pass this year. This bill will help crime victims just as well as it'll help the juveniles in the system. Why? Because it will keep juveniles safe. It will keep them safe during what I will argue is a very valuable transfer process, where we take the time in the state of Maryland to evaluate, to interview, to get reports ready for the court. Those kids during that transfer process, their attention is focused. Oh man, I'm in adult court. I better take this serious. But during that process, they need to be in a juvenile facility from the very start. So I've completely forgotten my entire notes here. So if you ask me questions about the money, the enforceability, why we've been in violation, I can tell you because I've been seeing it happen for years. But what I'm certain of is that this is the bill to pass. And when you hear all the arguments next week about House Bill 409, I know you will hear impassioned cries to take those kids out of the juvenile system. Our Maryland crime victims deserve a system with teeth to handle the most serious offenses. But those kids need to be in a juvenile facility and get some serious rehabilitation. But I'd love to address the money and the facility question if you ask. Thank you.
All right, thank you. They're lighting up. Delegate Marina.
How quickly could all this be implemented? Like, what's the timeline? Are the resources existing? Because
honestly, that's the one thing I look at from a practical standpoint. And I think, why are we delaying implementation? Mm-hmm. I've heard from Ms. Sample, I know she's here somewhere, from the counties, and I've talked to the heads of the jails across the state. They say, we didn't build a new facility. We didn't, nobody gave us all this money. We didn't have 2 years to implement this. We got kids that showed up on our doorstep, and we had to figure it out. We had to find a place to keep them safe, and that's thus the violations, because they can't always be perfect with this. So my question is, DJS over the last how many years has closed, and I won't have the numbers correctly, but we can all look at the records. They closed 2 or 3 locked facilities. Closed facilities. They've closed these facilities. They have them. There are beds available, like up in Western Maryland. They've used the money for other things. Those kids need to show up at their doorstep and be taken. Just like our Maryland jails do across the state, they take them even though they don't have the money flowing in to take care of it. DJS, I would challenge, will do it when they're forced to do it. But right now, the jails will take them. The violations occur, the 1,600 violations occur because the police transport they can't move them to a juvenile facility until the bond review the next day. And then the bond review, the judge, in all my experience, since the law changed, the judge has always ordered, unless it's a first-degree murder, they've always ordered they go to a juvenile facility. There is a delay of days, if not weeks, before the department says they're ready to take them. That's unacceptable, even under the current law, and this won't give them that.
well, if the government is going to, go through this process, it's on the burden of them to take care of these children at the end of the day.
It is. And I would argue they're going to come in here next week and say, hey, give us all of these very serious crimes. Let's change the charging statute. House bill you'll hear argument about for hours next week. Take all these serious crimes out of adult jurisdiction. Give them to us. We can handle it. Well, they can't even handle the immediate detention. So what does that tell you? Those serious crimes are going to be handled by the Department of Juvenile Services, and that sex offender is going to be right next door to you. Or the person that shot you is going to be in the house next door to you on an ankle bracelet, and we all know what can happen when somebody's on an ankle bracelet.
Thank you.
Thank you. Delegate Taylor.
Thank you, Madam Chair, and thank you for being here. I'm a new member on the advisory group and have heard all about these issues and violations, and we're just stunned. Like, it's just unbelievable. I'm actually looking at the information letter that DJS has submitted as testimony, and although they appreciate the delayed implementation and all that, it says without understanding how other necessary statutory reforms, particularly those affecting automatic charging and transfer timelines, will impact the current population, it's not possible for DJS to fully assess its ability to implement the provisions of House Bill 389 safely and effectively. These statutory changes are critical to creating the capacity required to serve additional populations within the juvenile justice system framework. It appears DJS is not taking accountability again. You asked that we ask you, based upon that and other things that you know, what are the facility changes and dollar values that you wanted to talk about that you didn't get a chance to share?
I might have already touched on some of that in my previous comments. My understanding, and I didn't read that letter, but I've heard that statement before, is that the department is advocating for House Bill 409 to pass. And therefore, they're going to say, hey, they're saying, we're going to get all these new serious cases that are just charged as juveniles. So give us a chance to figure out how to handle them before this. I would argue before we trust that agency, that we need to figure out if they can handle the youth already locked up. They need to be able to handle these. And I think the money issue is what I would just say. The jails are taking action because they know they have to. The department, I mean, it just happens. We all are juggling money and budgets, and until they're forced to, they're not accepting that youth at their door.
Thank you.
Thank you.
Thank you, Ms. Wilt. This concludes the favorable testimony on this bill. Oh, I'm sorry. Delegate Phillips.
Thank you. A couple of questions and thoughts. I want to get clear on process. A young person comes in, they go before a judge. The judge orders that they're detained, and in many jurisdictions, that means they're going to be detained in an adult facility. Is that?
If the judge orders that they be detained, they have to also make a decision about whether they're amenable to a juvenile facility. And the way the law is written, it's written very clearly. We have to move everybody unless there's a history of them beating up. I mean, that's layperson language, unless they're totally unmanageable in juvenile, and I haven't seen one of those. So the judge says go to juvenile, and the adult jail takes them and waits until DJS says green light, bring them over.
Yeah. What is the role of the state's attorney in that process of requesting detention or not?
Our first contact is at the bond review. And at every bond review in the jurisdictions I'm familiar with, the public defender comes in and makes a request about release. And then the next question is, Your Honor, we've also filed, there's a standard form that's on file with the court, and the court knows that all they have to do is check a couple boxes, and that happens immediately during that hearing. Unless there's a history of violence in a juvenile facility, I have never heard of a state arguing that.
And as I think through this one, We have closed a number of facilities. At any point in time, and I'm really stretching here, have we ever thought that maybe that's a purview of the local jurisdiction to provide some, as I think it was mentioned in one of the western counties, they've set aside a facility specifically to kind of hold the children, I'm assuming outside of sight and sound?
It will be outside.
Outside of sight and sound. Is that something that perhaps we should be looking at as well? Just because we've got this gap?
I mean, I can't speak on the financial or the number of facilities, Ms. Sample might be, but that's what's happening now, is that our local jails are finding either a wing or a section or a hallway that they can put that youth, or some little place that they can put that youth while they're waiting. But that, I don't think anybody would argue, is ideal for the juvenile. And it would be much better to be in the care of juvenile people who are trained to handle juveniles for sure. So I think what you're saying is happening to the best of their ability. And in Baltimore City, there's an agreement with the Youth Detention Center. So that place, the Youth Detention Center, is owned by the Adult Correction System. And if a juvenile under the age of 18 is convicted and serving a sentence in the DOC, they actually serve it there. And there's some agreement that Baltimore City kids can go there pre-trial, but that doesn't apply to any other jurisdiction.
Well, actually, there's a memorandum of understanding between Baltimore County and Baltimore City as well. But that seems to be a challenge because all of the beds are taken.
Yes. Yes, I think the
So
Youth
even when
Detention
we are
Center probably would like probably some more funding and space, but I can't comment on that.
All right, thank you.
Thank you.
Thank you. Delegate McComas?
I'm going to make this brief. Do you think it would be beneficial if this committee would have a work group to try to get the major players on all sides of this issue in the same room, and so everybody can say, no, that's not right, but at least find where's the consensus so this can move forward? I'm just wondering.
I love work groups. I just don't want to delay a positive vote on this. So I'm available next week and
well, I have no authority, but I'm just thinking in the past that kind of has gotten us over the hump on some issues that were very, very divisive, and it just seems like this needs to go somewhere because it's never gotten resolved.
I fully agree. The sooner
and
the
it may
better.
have not even been resolved when I wasn't around. So I just think that. And I've had some clients that have been in the system, and I'm wondering if things would have been different if things were different.
And I think my argument is that this is the #1 problem with the transfer system. We say, Maryland charges too many youth as adults, but the problem isn't the charging. We keep that secret from the community. Nobody knows about it. It's all hands on deck with a juvenile charged as adult. They get more services than anyone else. We take that away, they're going to be getting fewer services. There's less urgency. We don't need that for our serious cases. So this bill, I think, helps our kids.
Thank you so much, Ms. Wilt. That concludes the favorable testimony on this bill. I'd like to call the favorable with amendments, Ryan Ross and John Sexton. Could you please identify yourself, and you may get started when you feel.
Good afternoon, Vice Chair. Madam Chair, thank you. I'm Ryan Ross. I'm the past president of the Maryland Correctional Administrators Association and the director of the Charles County Detention Center. I'm here today in support with Amendment House Bill 389. We all agree that juveniles should not be held in adult facilities. The challenge in the bill is the temporary 6-hour holding exception that we've all talked about. It really doesn't work on the ground. In reality, it waters down the protections that the bill is trying to create. Adult intake and processing areas just aren't designed to provide sight and sound separation, and there's no realistic way to retrofit them. Even short-term holding will expose juveniles to adult populations. The 6-hour time frame really isn't achievable statewide. Many counties lack 24-hour access to judicial officials for initial appearances, and even where they do have that access, we as facilities, we have no control over when a juvenile is actually seen. Transportation is very complicated too. limitations, particularly during off hours, weekends, holidays. They really just compound things to make compliance unrealistic. To ensure House Bill 389 works without sacrificing protections, we respectfully request the removal of the temporary holding exception and require DJS to prepare an implementation plan by October 1st, 2027 that addresses judicial access and intake capacity. That plan should also allow for law enforcement to take juvenile arrestees directly to a nearby juvenile facility to be processed and seen by the courts as quickly as possible. With these amendments and with the bill's 2028 effective date, Maryland can meet the intent of this bill responsibly and protect juveniles without compromise. I do respectfully urge this committee to issue a favorable report on Senate Bill 296 with amendment. I do thank you for your time and consideration, and I'm available for questions.
Thank you.
If you have them.
Sir?
Good afternoon, Vice Chair, committee members. My name is John Sexton. I served 37 years. I just got out not too long ago. I was charged at 16 for a crime I committed when I was 16. I'm definitely in favor of this bill. It's about by the grace of God that I survived that, going in that young. But I think that there's a few things I would like you to understand. First is that almost all these kids at this age, it's critical that at that developmental stage that they not get corrupted. And the system that I just came out of, I'm telling you now, they will chew them up and spit them out. And they will become corrupted, and that's going to lead them on a pathway that they're going to habitually offend. They're going to and be a problem for most of their lives. I'm requesting that you consider amendments simply because I don't think that there's enough articulation in this bill to give DJS or the adult prison system a focus about what it is they have to do. It gives them parameters about what they can't do, but it doesn't push them in the direction of what they need to do. And what's going to happen is many of these kids, they're going to get segregated. When we were in the hearing yesterday, DJS was doing a lot of pushback about how they're going to handle these kids, particularly the ones that have already been convicted in which they have to house. And from their perspective, they're going to be a security threat. And that means they're going to get relegated to the side somewhere, and they're just going to be warehoused waiting until they turn 18 to get slung up to the adult system. And I don't think there's enough forethought into what that process is going to look like. And then when they do get thrown up there at 18, are we just going to throw them to the wolves too? Right? We're going to protect them now, and then when they turn 18, we're just going to throw them up there for the same thing to happen that we want to protect them from today. Just because somebody turns 18 doesn't mean that they have all the wherewithal to protect themselves and to stay focused. Thank you.
Well, thank you both, and thank you for Charles County for being here. And Mr. Sexton?
Yes, ma'am.
Thank you for sharing your story to make sure we help other kids.
Yes, ma'am. Thank you.
All right, that concludes the testimony on this bill on HB 389. Next. You want me to keep going? Okay. What's the next bill? Is Delegate Tavares here? Yes, you want to come forward? Is that us? HB 384? Yeah, she waved. I just chose the next one. I couldn't find my list. I'll do 53 next. Who is it? Okay. Is she here?
You want to sit over here? Oh, sure. Yeah, that way we could get the mic action.
All right, Delegate Tavares, you can get started.
Well, Honorable Chair Davis, thank you, everyone. and esteemed committee members, it is an honor to be before you all. Again, I am here to ask for your favorable report on HB 384, Family Law Child Support, Capacity of Minors to Initiate and Defend Action. This bill grants underage mothers the ability to file for child support without the permission of a parent or guardian. Across the state, young mothers face significant barriers when seeking the financial support of their children, often due to parental consent requirements that delay or prevent timely action. This is not just an issue of legal access, it impacts the well-being of children, the stability of young families, and reaffirms cycles of poverty. We see this in foster care cases and unaccompanied minors living on their own or even with parents. In our state, around 5% of births each year are to teen mothers, many of whom face financial instability. Nearly 3% of teen parents live below the poverty line. These circumstances are exacerbated when teen mothers cannot access child support due to legal hurdles. For example, in Prince George's County, the teen birth rate for those ages 15 to 19 in 2020 was 42.2. That's the teen pregnancy rates per 1,000 females. Now in 2023, that is 31.8, which is it's great. It's a decline of 30% in Baltimore County. That's 76 in 2020, 94 in 2021. In 2022, it was 78 and 63 in 2023. So in all of this, what I just want to say is that particularly when we're looking at particularly Hispanic females, there's a 2 to 6 times higher percent pregnancy rate when you compare that to all pregnancy rates across the state from 15 to 19 per 100 per 1,000 females. Now, teen mothers are less likely to complete high school, with only about 50% graduating by age 22, compared to 90% of women who do not have children during adolescence. By allowing young mothers to file independently, can I finish, please? This bill addresses the critical need and ensures these young families receive the support they deserve. Through this legislation, we seek to provide a practical solution that helps these young mothers exercise agency and advocate for themselves and their children. It will empower them to take responsibility for their child's well-being and ensure access to financial resources necessary for a more stable future. Moreover, this bill will reduce the burden on public assistance programs by promoting self-sufficiency. In closing, I ask this esteemed committee for a favorable report on HB 384, which supports our young mothers and their children. And I'll pass it over. Which one of you wants to go first? Oh. It's like double dutch.
Good afternoon, Vice Chair Davis and distinguished members of the committee. And thank you, Delegate Taveras, for bringing this bill. My name is Erica Lamont. I am the Advocacy Director for Children's Rights for Maryland Legal Aid. First and foremost, I want to clarify and to highlight that child support is for the minor child. It is the right of the minor child and not a privilege for a parent. It is designed to meet the child's basic needs, such as food, housing, utilities, education, medical, and that's just to name a few. These needs do not change based on the age of their parent. And the child should not be punished because of the age of the parent who's responsible for their care. Speaking of responsibility, without access to legal remedy is inequity. Access to failure to provide these minor parents with access is a failure on our part. I want to bring also attention to a special subset of teen parents who are in foster care that have custody of their children. So just because you may or may not know that just because a child is in foster, a teen parent is in foster care, does not mean that the Department of Social Services has care and custody of their parent. There are teen parents that have custody of their own children. I'm sorry, custody of their children. They have custody of their children, and they're responsible for all of their needs, financial and otherwise. And so these children who are parents in foster care are there because of abuse or neglect, and so they can't rely on their parents to file for them. So for these reasons, I am asking that you issue a favorable report for HB 384.
Thank you. You may proceed.
Thank you, Madam Vice Chair, distinguished members of the committee. My name is Michelle Smith. Some of you know me. I'm from the Maryland State Bar Association here on behalf of the Family Law Section. We have talked about this bill last year and this year. We supported it last year with amendments. Those amendments are contained in this year's version. Those amendments were address the capacity of a minor to defend in a child support action too, because we believe it's really an access to courts and an access to justice issue. There are already provisions in the law, as you might have noticed in my written testimony, under Rule 202, which provides some access for certain teen parents, but not all of them. So if you're a teen parent who needs child support and you do not have a guardian, a fiduciary, or a next friend, you're out of luck. No access to the court for you, for your child, until you are an adult. And that doesn't seem fair. I think there will be some questions about implementation, but despite those questions that may hopefully get answered, we are in favor of access to the courts for teen parents, actually whether they be female or male, and that is important because our Maryland children deserve child support for every parent, not just adult parents. Thank you. We urge a favorable report.
Thank you. I don't see any questions. Pretty unusual. Okay, thank you for coming. Thank you for being here.
Thank you very much.
There's no unfavorables, so we're going to move. That concludes the testimony on this bill.
Thank you.
Next.
Take it while it's good.
Next, I'd like to call Delegate Smith and HB 84. You may begin.
Thank you, Madam Chair and esteemed members of the House Judiciary Committee. For the record, I'm Delegate Stephanie Smith, and I'm here to present House Bill 84. It is known as the Providing Alternatives Through Healing for Justice-Involved Individuals, but we will be referring to it as the PATH Act. The reason why we're bringing this bill today is, quite frankly, it's a bill about accountability. It's about right-sizing accountability for defendants who, when they are facing sentencing for their crime, expanding the opportunity for the court to assess if domestic violence has been a significant contributing factor to the underlying offense. And that can help the court to determine if perhaps there should be a reduction in sentencing. And for those who are seeking petitions for resentencing, it also allows for those details and that information to be assessed by the court. It also expands the universe of information that can be used to establish the fact that the defendant has experienced domestic violence. Now, one of the reasons why this bill isn't just important for women and others who are impacted by intimate partner violence, we actually have, through some of the experts you'll hear after me, a PATH Act impact report for 2026 that will be provided to maybe the clerk to provide to all of the staff at the conclusion of the hearing. And some of the things that are shared in there that I think are very sobering is that it discusses that 65 to 85% of all women in Maryland systems of incarceration are survivors of sexual assault. Domestic violence and incarceration issues for women are dramatically disproportionate to men. 70 to 80% of incarcerated women experience intimate partner violence, and 60 to 70% of incarcerated women endured childhood physical sexual abuse. Now, this particular data point is sobering. Black women are only 15% of the population of the state of Maryland, yet they represent over 57% of all women that were murdered as a result of domestic violence. So while domestic violence touches every income level, every racial group, and every corner of our state, there are some members of our state that are even disproportionately impacted by the threat of domestic violence. One of the reasons why I was compelled to serve as a sponsor, I have a cross file with Senator Hinson across the street, is that when my mother was pregnant with me, she didn't get, she never knew what she was gonna have. She had a boy name and a girl name. You see what happens. But she knew in her heart that I was going to be a girl because my cousin had been murdered by her husband. And in her heart, she felt I would be the person to replace her. My godmother, an accomplished physician, she was a victim of domestic violence by her lawyer husband. So I ask you today to help me help those victims who are not asking not to be held accountable, but just to have the accountability right-sized. The courts cannot be fair if they're unaware. And so thank you for your time today, and I will, of course, yield to the panel. Thank you so much, Madam Chair.
All right, thank you. Who would like to go next? Ms. Muhammad? You want to start there and let's move to the other side?
Yes,
Thank you.
Yes, ma'am. Good afternoon, and thank you for having us here today. I am Dr. Mildred Muhammad, an award-winning global keynote speaker, certified domestic violence advocate, and the former spouse of the DC sniper. I'm here because the PATH Act addresses a truth this system has failed to confront, especially for Black women. Because of his threats to kill me, a judge granted me a lifetime restraining order. However, visitation with our children was still included in that order. In 2000, before the shootings, he took our children out of the country instead of returning them from a scheduled visitation. I repeatedly sought help from law enforcement and the FBI. I told authorities I was in hiding because he told me, "You have become my enemy, and as my enemy, I will kill you." I was not taken seriously. Instead of protection, investigators told me they wanted to put me in the middle of a parking lot and use me as a decoy to lure him out, arrest him, and return our children to me. I refused. I said he would shoot me from a distance and they would not know which way the bullet came from. Their response was, "We're just trying to help you out." During the shootings and without my knowledge, I was placed under security. I learned later that security was removed and reassigned to someone in authority. When I asked what would have happened if he found and killed me, I was told they would have considered my death as a oops. After his arrest, I was treated as a potential accessory. In the DC sniper case, the court refused to allow evidence of domestic abuse, calling it insufficient evidence, even though law enforcement and the prosecutor stated I was the intended target and the reason he came to this region. That ruling caused domestic abuse from the courtroom. That's why many people did not associate that case with domestic violence. If attorneys Greta Gardner and Patricia Baker-Simon had not stepped in to help secure my own criminal defense attorney, I would have been mischaracterized as an accessory to a crime I was surviving, not committing. This is not just my story. It is one that happens to Black women when they are not believed, not protected, and then criminalized for surviving. The PATH Act does not excuse a crime. It allows courts to consider the full truth, so accountability is grounded in reality, not bias. For these reasons, I request and urge a favorable vote for the PATH Act. Thank you.
Thank you. Dr.
Thank you for having me, Madam Chair and Madam Vice Chair, and to the Judiciary Committee. I would like to say that this PATH Act is very important and it's very personal to me. And 28 interns, including Professor Moit over here on the side, we started working on this project April of last year. And the reason why it's important to me, because unlike Dr. Muhammad, which she was able to get out of the situation that she was in court, I was not. And 16 years ago, I was a victim of financial and psychological abuse by a male who was my fiance. And he stole money and stole clients, and I mean, he did all kinds of stuff. It was just horrible. He convinced me to help him start a business, and I did that. And then once I started the business, he told me to leave. So anyway, I had a corporate attorney for years. I had a CPA, and they knew what I was going through. Anyway, a year later, you know, we finally got him out the way. Then I had to deal with, here come the feds. And so in the court hearings, one of my attorneys kept telling the courts that, you know, this woman is a victim of domestic violence. This woman is a victim of domestic abuse, financial abuse, and things of that nature. But they would not accept that. And so that's why this PATH Act is so important, because how can a judge make a fair ruling if he or she don't have the full picture? That's number one. Number two, my nonprofit, Helping Ourselves to Transform, we have a MOU at DPSCS with MCIW. And I know at least 24 women right now that are sitting over at MCIW that are emphatically innocent and are sitting behind the wall because their domestic violence and abuse that was done to them was not considered. I urge you to vote favorably. Oh, my name is Dr. Carmen Johnson. My apologies. But I urge you all to vote favorably and really understand the importance. You know, people are sitting behind the wall, and they are emphatically innocent, especially Indigenous Black women. The numbers are astonishing, and you guys should really understand that too many women of color are being in prison and their stories are not being heard. Thank you.
Thank you.
Good afternoon, Delegate Bartlett and Vice Chair Delegate Davis. Thank you so much, and the Judiciary Committee for hearing us today. My name is Sonja Owens, and I'm a licensed clinical professional counselor, and I'm also the president of Helping Ourselves to Transform. In working with women, and men, but more so women, I've experienced lately, I'll say in the last 2 years, more women sharing with me about the fact that they've been subjects of domestic violence, and not just domestic violence, but also financial abuse. Where their mate has asked them to stay home to take care of the kids or to take care of the house, and it was presented to them as a plus, where they could be, you know, less stressed out with corporate America, and that he would take care of them, giving them an allowance. Well, it turned out later that when she did not do what he wanted her to do, no money came forth, and the money was withheld. I'm not giving you anything because you didn't cook what I wanted you to cook, or the abuse of the finances came forth. I've even experienced women being coerced and pressured into criminal activity. I've had a client recently in 2025. She was a property manager, When her spouse found out, well, her significant other found out that she had access to the accounts, he forced her to embezzle. Well, of course, nobody in the background knew about the gentleman. They only knew about the young lady. She later found herself facing 25 years for embezzlement. It is very important that the PATH Act be passed for the evidence of violence and domestic violence, coercion, manipulation needs to be presented when judges are passing sentence. Thank you.
Thank you.
Good afternoon, Chairman Bartlett, Vice Chair Davis, and of course, my delegate, Kim Taylor. I'm honored to be here today. My name is Olinda Moyd, and I speak to you today on behalf of the Maryland Alliance for Justice Reform. I interact with individuals behind Maryland's prison walls on a regular basis as a person who provides direct representation in post-conviction matters and also as a volunteer, as a legal educator in our institutions. I repeatedly hear the stories of domestic violence and abuse, which in many cases led to the individual's involvement in the criminal legal system. This bill is not about not holding people accountable. It only becomes relevant after there has been a conviction. It merely examines the totality of the circumstances so that the judge at the time of sentencing has a full picture of abuse and trauma that the individual endured. Survivors of domestic violence are often engaged in criminal behavior as a direct result of their abuse, coercion, and control. Sentencing is a critical phase in the criminal legal process. The judiciary must have before it all relevant information. This bill creates a framework where judges consider domestic violence as a mitigating factor. The bill is also important in that it allows information to come in through reports and testimony from family members, friends, counselors, co-workers, and that's also important because we know that domestic violence is not always reported to the authorities. We support a favorable report on this bill so that those who are sometimes invisible to our criminal legal system can be seen and heard. Thank you.
Madam Chair, there was an amendment I forgot to offer that just is a clarifying amendment to ensure that all manner of sex crimes are excluded and crimes that impact the vulnerable are excluded from the PATH Act. But I just wanted to make sure for the record that they're introduced.
Okay, okay. So you're going to supply the
Yeah, I have
committee?
it here.
Okay,
Yes,
great.
ma'am.
There are other amendments that have been discussed in testimony, which we will share with you so that you can see that and see if it's something you want to consider.
Absolutely.
So I have a question for you, Delegate Smith. So with the bill, just the four corners of what I can see here without amendment, it is the testimony or the evidence that we are asked to consider, asking the court to consider, is only at the time of sentencing?
Or petitions for resentencing too.
I'm sorry?
I'm sorry, and petitions for resentencing as well. So sentencing and yeah.
But it wouldn't affect the charging or the trial or anything of that sort?
No.
Is that evidence admissible now in a trial at all?
My understanding is that it is, but I think that there's irregularities around people's understanding about how to deal with that evidence.
Okay, thank you. Members, do you have any questions? Delegate Taylor?
Thank you, Madam Chair, and thank you, Delegate Smith, for bringing this bill. You know, I fully support the intent of this bill and have talked to many of these ladies many times, and hello to you, my constituent. I guess my question really is for Ms. Muhammad, who said that your estranged spouse had told you that he would, or no, you said, I'm just making sure I got this straight, that he could snipe you pretty much, and then he became a sniper, right? So you had like really solid evidence that this person's personality or character was eventually what it all played out to be. So I just wonder, in your case, were you able, was any of that evidence or testimony from you able to be used in that case? And that's my first question. And secondly, because you might just be able to lump it all together, were you ever incarcerated for anything that, you know, that maybe you had to do to him because he did things to you? I'm just making sure that, you know, we've got the whole story.
No, ma'am, I was, no, ma'am, I was not incarcerated.
Thank you. So we can take that off the table.
Yes, ma'am.
Yes.
I only testified during the sentencing phase without the jury. So that's the only way it came in.
And that was because you weren't allowed to, or you weren't asked to? Or?
The judge stated that it wasn't sufficient evidence, even though I was the reason, right? Even though I was the reason he came to this area.
Thank you.
Seeing no further questions, that concludes the testimony for this panel.
Madam Chair, how would you like to handle the distribution of this?
If you wouldn't mind providing us a digital copy.
Okay,
to the okay. A digital copy would, so we can make sure everyone gets it, if someone's not here today.
Okay, no worries.
Thank you so much, Delegate. Is Lydia Watts here? Is Lydia Watts here today? No, she's not here. Okay, thank you. Mr. Marquez Moore? Is Mr. Marquez Moore here? Okay. And Sakiala Saki?
Oh, I'm here.
Great. Deborah Williams?
She's not here.
Thank you. Melody Hession? Okay.
That's me.
Gotcha. Christopher Dews and Kimberly Watts. Zoom? Okay. Well, are ready to begin.
Good afternoon, Chair Delegate Sandy Bartlett, Vice Chair Delegate Deborah Davis, and members of the Judicial Committee. My name is Sakila Saki, and I am a resident of Hyattsville, Maryland. I am a sociology major at Bowie State University and a future social worker committed to trauma-informed care and community healing. Because I believe people deserve support before they are written off, I have been a lead intern and executive assistant with Helping Ourselves to Transform since 2025, working under the guidance of Dr. Carmen Johnson. I am also a creator and a collaborator on the PATH Act, and I am here today in strong support of the PATH Act. From a social work perspective, I have learned that justice is not only about what someone did, it is about what they have experienced, the system that have shaped their lives, and the support they need to order to change. Many individuals who came into contact with the justice system are living with unaddressed trauma, untreated mental illness, or substance use disorders. For far too long, our response has focused on separation rather than healing and stabilization. The PATH Act gives Maryland a more effective and human option. It allows court to slow down, to assess the whole person, and to respond in ways that reduce future harm. It creates space for treatment, support, and accountability to work together, which aligns directly with evidence-based trauma-informed social work practice. This bill matters because it reflects a core social work principle. People are more than their worst mistake. When individuals are given the opportunity to address the root cause of their behavior, whether trauma, mental health needs, or addiction, they are far more likely to stabilize, support their family, and return to the community in healthier and more sustainable ways. I have seen how access to right services at the right time can interrupt cycle of harm and that will otherwise continue across generation. This is just not compassion. It is responsible, evidence-based leadership. This bill aligns justice with social work values and evidence-based practice and represents the kind of future-focused, favorable policy Maryland should embrace. Thank you. Once again, my name is Tequila Saki.
Go next. Good afternoon, everybody. My name is Christopher Dews, representing Out for Justice. Out for Justice is a nonprofit in Baltimore City that specifically is designed by returning citizens to help returning citizens. This is a bill that is very, very near and dear to our hearts. We actually had a women's symposium last summer where we talked about issues that impact our formerly incarcerated, pretty large membership base of women, and this was a constant theme of individuals who were being charged in relationship to crimes that they committed because they were victims of domestic violence, from staff to members. We've had situations where, and I've seen pictures where, let's say a gentleman would have beaten this woman to an inch of her life repeatedly for months, for years, and then she took matters into her own hand. We had one woman that I can speak of that she did 24 years on a murder charge when she was 24 years old, is how I remember this, and the evidence was clear that this woman was a victim of domestic violence. However, the courts did not necessarily use that evidence. So we support this piece of legislation because we know that it says that this evidence will be brought before the judge, and not just in a possible way, but actually brought before. I think the language says shall specifically. And we're also aware that there are many advocates who have a lot to say about this issue. We're happy to work with the sponsors of the bill, Dr. Carmen Johnson, who's done a phenomenal job bringing together a very, very robust and powerful coalition, as well as all the other advocates who really are working to strengthen this issue so that less and less women are in positions where they find themselves doing extensive amounts of time because they were victims of domestic violence. And for those reasons, we urge a favorable report. Thank you.
Good afternoon, Delegate, Chair Delegate Bartlett and Vice Chair Delegate Davis. My name is Gwendolyn Levi, and I'm here to testify in support of the PATH Act. As one who served 9 years of a 400-month federal sentence at MCIW as a result of a reciprocal agreement between the federal system and the state correctional system, I was released after serving 16 years in 2020 on compassionate release by my judge. Okay. During that time, I was able to see and talk to many, many women like myself inside the federal institution and the state institution of MCIW who stated that even though their case didn't involve domestic violence, there were other charges before that they had been convicted of. Domestic violence had been, was, and still is a factor in their behavior. Please read my written submitted statement. We're asking that you not allow the courts to continue to address our criminal behavior without addressing the root causes that affected that behavior. Maryland has a chance to continue its path of criminal justice reform by passing the PATH Act so that no trauma continues to affect that, so that the trauma that continues to affect our actions can be recognized by our courts. I urge you to vote favorably for SB 138. I want to thank Senator Smith and, Delegate Bartlett and Delegate Davis and the Helping Ourselves to Transform organization for bringing this issue to the forefront. Thank you, and I urge a favorable report. Thank you.
Good afternoon, delegates. My name is Reverend Melody Hession. I'm here testifying on behalf of the Delaware Maryland Synod for the Evangelical Lutheran Church of America. We've got congregations all over the state, including inside Maryland Correctional Institute for Women. Last year, 3 Lutheran members of our church body and residents of MCIW submitted testimony in support of the Second Look Act, pouring their hearts out in their stories. Very eloquently, and sexual assault was part of all 3 of their stories in the context of the crimes that they were convicted for, that they were serving sentences for. For none of them was their own trauma or victimization a meaningful part of the conversation at sentencing. Anyone in our denomination who's volunteered with our Lutheran congregation at MCIW learns from getting to know the parishioners that in our justice system, each person is treated as either a criminal or a survivor, and unfortunately, there is little room for anybody to be both. These 3 Lutherans I'm here for today are 2 women and 1 trans man. So we do appreciate that this bill acknowledges the trauma-informed sentencing is really needed for different, identities in our prisons. So our church absolutely believes in more trauma-informed sentencing practices in our court system. We both urge a favorable report for this bill, and we hope that you, as a committee, pay attention to the lessons from this bill about who is already inside of our prison walls in Maryland. Thank you.
Thank you. Members, do we have any questions? Delegate Conaway?
Chair, thank you, panel, for coming in to testify. Mr. Dews, you said sometimes these people will have been victims on several different occasions, and then maybe a subsequent occasion, there might be a reaction that causes a person to become incarcerated. Can you speak to why that further action should be considered?
So in the specific example that I was thinking of when I said that, to be clear, this gentleman, the gentleman who was causing the domestic violence, was a very prominent member of government. And so not necessarily in the legislative side, but so when it came to the power dynamics, the individual that was the victim did not believe that when she tried to make reports or speak to this specific situation, that it wasn't necessarily heard or taken as seriously as it should. That's in that specific example, which then, in fearing for her life, she decided to take an action.
Sure. So that's one specific example, or does that happen in several different examples as you know of?
I will not speak to all the different examples that exist, as I don't know all the details. Well, I will say for in that specific example, I think that is what happened. The other example of the woman with 24 years, I don't necessarily think that individual was in a position of political power, or I just don't think that individual was in a position of political power, but I don't think I would be the right person to speak to
On page 2 of the bill, you have line 11, revenge porn. So could you talk a little bit why you think the revenge porn should be considered at the time of the sentencing?
I would like to pass that to the other members of the panel, if that's okay, Delegate.
Fine. The chairs.
You want to speak to that? You can repeat the question, Delegate. Sorry.
As a part of the bill, you have several different actions that should be considered, and one of them is revenge porn, I believe, on page 2 of the bill, line 11. So you would...
Can you repeat the question? You want us to talk about that particular part?
Why that should be considered, why that should come under the consideration, right? That would be considered also, right?
That would be, yes, that would be considered also.
Yes, and I would like for you just to articulate why that should be considered.
Yeah.
Let the sponsor of the bill take that one. So the question is, why is revenge porn or sextortion or things of that manner, why should that be considered domestic violence? Is that what you're asking?
Okay, go ahead.
Do you see that as abusive, harmful, psychologically?
Do I see it?
Yeah.
Oh, I'm not here to answer that question.
But I'm just saying, I think
trick,
that...
that's a nice trick.
No,
though,
I think,
no.
just in all seriousness, our law has always existed before some of our innovations in technology and science. I mean, abuse has happened since, you can look in the Bible. Abuse has happened forever. But the ways that people can be abusive and controlling and harmful to people keeps evolving because our society keeps evolving. Can you imagine the great level of shame that we see people feel through sextortion cases to the point they take their own lives. I think that's an example of how harmful being exposed in such a fashion has been found to be for members of our society. It's deeply psychologically painful and harmful to be exposed in a manner that either was against your will or you didn't even know you were originally photographed or videographed in the first place.
Right.
So,
but my question was from page 1, line 5, for the purpose of authorizing the introduction of evidence that a certain defendant was a victim of domestic violence and that the domestic violence was a significant contributing factor.
Yes.
And what I'm trying to get to is, do you consider the revenge porn as being a considerable, significant contributing factor? Okay.
Yes, it could be. Depends on the case, obviously, but yes.
So it could be.
I'm a lawyer, so the answer will always be it depends.
Okay, all righty. Do you agree with that, Mr. Dews? It depends?
Yes.
Okay, thank you very much.
Very good. Delegate McComas.
I'll make this quick, Madam Chair. Just real question. Are there any other states that have passed this type of bill for mediation of a
New York.
There's 3 different states.
It's 3 different states, New York, Ohio, and
could you just
Georgia.
Okay, so let me just write it down.
We're going to send you the digital version of the report that details all of that.
Great. Okay, thank you very much.
That way you don't have to worry about it. I miss you.
Great. Members, any further questions? Seeing none, that concludes this panel. We're going to move to our next panel. Everyone is online. We have Crystal Combs, Kimberly Watts, and Greta Gardner. Okay. We'll work with who we have. Hello, Ms. Watts. Good to see you.
Good to see you, Delegate Bartlett. Thank you very much for your time.
Whenever you're ready, you may begin testimony.
Sure. First, let me introduce myself. My name is Kimber Watts. I'm a 25-year veteran attorney of the Public Defender's Office, currently the chief of the Forensic Mental Health Division. One of the many kinds of cases that we deal with are actually the battered spouse syndrome cases. So before I talk about this bill, first let me answer Delegate Bartlett's previous question, and that is that the battered spouse statute only allows for battered spouse evidence to be admitted in first-degree murder and first-degree assault cases. So it doesn't really have an impact on this particular bill, and it's only for purposes of challenging the defendant's mental state. In other words, in those crimes, whether they actually believed that they were in imminent danger, that in turn has the effect of mitigating an offense downward. So potentially from first-degree murder to second-degree murder, or first-degree assault to second-degree assault. That being said, during sentencing hearings, we are allowed to introduce evidence of our clients being victims of domestic violence as mitigation, but the ground truth that we see is that their experiences as survivors is not always seen as a mitigating factor by courts. So first, let me talk about the sentencing guideline structure in Maryland. Unlike federal court, where a sentence must be within the guidelines, here we only have to fill out the guidelines worksheet and they have to explain why they departed from a guideline. Being a survivor of domestic violence isn't even one of the guidelines codes. And I think that that says a lot about the seriousness with which it is taken as mitigation. This bill would also allow the court to depart from mandatory minimum sentences. Wouldn't require them to, but it would enable them to. Lastly, I would say the Maryland Office of the Public Defender supports this bill with the amendments proposed in our written testimony because it recognizes the inherent humanity in our clients who've been victims of domestic violence and allows for just and compassionate sentencing in light of that. Thank you.
Thank you. Is that Ms. Combs?
Chair, Vice Chair, honorable members of the committee. My name is Crystal Combs, and I serve as Vice President of Helping Ourselves to Transform. I'm also a survivor of long-term domestic violence, financial abuse. I urge a favorable report with House Bill 84, the PATH Act. When people hear domestic violence, they often picture bruises, but many of us were controlled in ways that never left visible marks. Financial abuse is one of the most powerful and least recognized forms of domestic violence. It is about power, control, and survival. There are women who are completely financially dependent on their abusers and cannot leave because they have no access to money. Then there are women like me, educated, employed, financially responsible, whose partner systematically destroys their financial stability. My former spouse exploited my trust, forced financial decisions under pressure, created debt in my name, and weaponized the legal system against me for years. The financial damage was devastating, but the trauma was even worse. The stress became so severe that it affected my physical health. I lived in fear for my life, not only for my safety, but for my livelihood and career and my secret clearance. Even after leaving, the abuse continued through court battles, financial sabotage, and harassment, even till today. This is what many survivors face. The violence doesn't end when the relationship ends. If I did not have God on my side, I could have lost my mind and killed him. Now imagine a woman in that situation who makes a desperate decision just to survive, to keep housing, to protect her children, and to escape coercion. Our current system often punishes her without even considering the abuse that shaped her circumstances. The PATH Act changes that. It gives courts the ability to see the full picture, to recognize financial abuse, coercive control, and trauma, and to respond with accountability and healing. The approach reduces recidivism, strengthens families, and improves public safety. Healing is not soft. It is smart justice. I respectfully ask for a favorable report on the PATH Act. Thank you for your commitment to justice that truly heals, transforms, and prospers.
Thank you. Members, do we have any questions? Ms. Watts, I have a question. Sure. You can't see this, but I just wanted to ask you about something that the Office of the Attorney General mentions in their testimony. And they suggest a standard requiring that the crimes be committed in whole or in part as a result of the coercion, control, economic abuse, or other circumstances arising from domestic violence. Would you like to respond to that? And is that something that you think, yes, would you like to respond to that?
Yeah, I would say that really sentencing should look at the entirety of a person's circumstances. We should not be sentencing someone solely on the worst thing that they've ever done, but on who they are as an individual and as a human being. So I don't think that that really furthers any goals, honestly, that amendment.
Okay. And then lastly, I just wanted to ask you about the testimony from MSAA in which they state that this is putting a burden on the individual who is seeking a reduction of sentencing to prove that there is, in fact, domestic violence. Can you respond to that?
It does do that. We, of course, wouldn't be opposed to that burden being removed, but I think when it comes to resentencings, you know,
it's always, are you saying
it's always a challenge?
There's always a burden. I got you. Okay. Right. Thank you. Thank you very much, Ms. Watts.
Take care.
Thank you. Did Greta Gardner ever come online? No. Okay. Well, then that concludes our testimony for House Bill 84. Thank you. Thank you. We're going to move on to House Bill 53, Delegate Lehman.
Thank you, Madam Chair. Can I bring up my panel?
Yes, please.
Stacey Fullerton, Fullerton, Aaliyah Tana, and Andrea Crims. And then I have one virtual witness,
Okay.
Madam Chair.
I could hear Stacy Vloden, and is it Ms. Shiwadkina?
I have a substitute. That is a student, and I have a substitute, Madam Chair. If
Okay,
you
so
would
tell me the
allow
names
for that
again,
for
please.
another, student.
Yeah. Can you tell me the names again, please? That you're calling up.
Andrea Crims. Okay.
Okay. Just so I don't forget to check anybody off. Okay. I tell you what, once you begin testimony, just tell me your name then. Delegate Lehman, you are welcome to start whenever you're ready.
Yes, thank you, Madam Chair. Good afternoon, Chair Bartlett, Vice Chair Davis, and esteemed members of the Judiciary Committee. For the record, I'm Delegate Mary Lehman, requesting your favorable consideration of House Bill 53. The legislation is an update to Maryland's existing law prohibiting the trade, breeding of, or possession of specific wild animals, but includes common sense exceptions. The goal of the legislation is to strengthen public safety, relieve burdens on local law enforcement and animal management staff, and ensure the humane treatment of wild animals. Current Maryland law bans the trade, breeding, and possession of dangerous species, including bears, non-human primates, wild cats, and some poisonous snakes, with exceptions for certain licensed facilities such as zoos, aquariums, and animal sanctuaries. It has been more than a decade since this law has been updated. HB 53 builds on that established foundation by adding zebras, kangaroos, wallabies, and wallaroos to the list of species that may not be privately owned. These are species whose recent escape and injury records make clear that they pose significant risks when they are kept by private individuals. HB 53 also repeals an outdated exemption for so-called helper animals without affecting legitimate service animals. So public safety concerns are neither hypothetical nor rare. Just last Saturday in snowy Nelson County, Virginia, which is about 35 miles from Charlottesville, an adult kangaroo escaped from a private property when it was fleeing a hunting dog that had gotten into its enclosure and started to chase it. The kangaroo jumped an 8-foot fence, ran several miles to US Route 29, very busy highway, where it caused, not surprisingly, a traffic jam. Sheriff's deputies managed to get the kangaroo out of the travel lanes, but had no way to contain it. Eventually, the owner did come and used a tranquilizer gun to subdue the kangaroo. The incident could easily have caused a major traffic accident and injured or killed people as well as the kangaroo. In Maryland, in 2021, multiple zebras escaped from a USDA licensed breeding facility in southern Prince George's County. Some of you may remember that incident. It roamed these zebras roamed residential neighborhoods for months, which triggered a multi-agency response. Former Department of Environment Director Andrea Crims, who is right here to my right, will talk more about that incident and the county resources that were used in an attempt to find the zebras. Similar problems occur nationwide and involve other species as well. Kangaroos, wallabies, and wallaroos have escaped at least 83 times across 25 states in the last 10 years. These are all wild animals capable of inflicting serious injury to humans, but adult male kangaroos in particular are risky because they can be over 6 feet tall, weigh up to 200 pounds, and are very strong. Madam Chair, I'm just going to end by talking about that in addition to this private ownership ban, the bill will change the exemption for so-called helper animals, which is too narrow and outdated. I can take questions about that. But I want to emphasize the reason for adding to the existing list of species that would be banned in cases of private ownership is the danger that they pose both to the owners and to the public at large if they escape. Okay. I respectfully urge the committee to give House Bill 53 a favorable report, and I thank you. And if I could ask Stacy Vloden from the Humane Society, or renamed, I'm sorry, Humane World for Animals, to go next. Thank you.
Hello, Chair Bartlett, Vice Chair Davis, and esteemed committee. My name is Stacy Volodin. I am the Maryland State Director for Humane World for Animals, formerly known as Humane Society of the United States, here on behalf of our supporters to urge a favorable report on House Bill 53. I'm going to skip over a lot of the facts that Delegate Lehman touched upon and get right to why we're supporting this. It's a very simple bill. It adds to already existing framework. We already have the other dangerous animals added into our bill. Currently, there is a booming trade in particularly kangaroos. So that's why we added kangaroos to the language when Delegate Lehman came to us wanting to address the zebra matter, which you will hear more about. You can buy them very easily, which you will also hear more about in a few minutes. But we feel like this is a very simple, clean bill. We are simply trying to address a growing new trend with the zebra trade and the kangaroo trade. We do, within the Humane World for Animals, track these dangerous incidents and included a long list within my written testimony. You'll find it in the appendix if you are curious. These incidents are increasing and increasing and increasing. They do come at significant costs. I will not be the person to discuss that. I think there is a better expert here for that. But Animal Services, Department of Natural Resources, and local law enforcement have to respond when these animals do break loose. So I think that's really important to understand. We do know that there is a kangaroo kept as a pet within this county within a narrow radius from us right here. This is not as uncommon as any of us, I think, could imagine. Additionally, I think it's really important to say that professional animal workers of Maryland do support this bill. Those are the leadership within shelters and animal control agencies. I urge a favorable report on House Bill 53.
Madam Chair, if Andrea Crooms could go next, please.
My name is Andrea Crooms. Oh, thank you, Chair, Vice Chair, and my own delegate, Delegate Taylor. Hi. My name is Andrea Crooms. I was the director of the Department of Environment in Prince George's County, which oversees animal control in Prince George's County in 2021, when 3 zebras escaped from a herd of about 50 zebras in southern Prince George's County. Over the next 3 months, we would expend a tremendous amount of resources assisting in the catching of those zebras and keeping people from getting harmed from those zebras being in the roadways or interacting with other humans. And over the next 2 years, well, until the criminal and civil cases against the owner concluded, it took an inordinate amount of my time dealing with zebras. I'm here today to express that the cost in dollars and in terms of time in local governments of overseeing individuals who own exotic animals is untenable. There's no state agency that oversees exotic animals. That responsibility falls to counties and municipalities. The knowledge of exotic animals, both from an animal husbandry and legal compliance perspective, is not commonly known. I served as a criminal attorney in the state. I have a master's degree in agriculture, and I taught veterinary science at the graduate level in 2 international universities. I don't know anything about zebras. So I had to learn it, right? I had to spend all of this time learning it. We don't have the tools to catch the animals. We have to borrow them or buy them. We don't have the facilities to house them. We have to rent them. We don't have the facilities to transport them. We do not have the knowledge to take care of them. We do not have the knowledge to understand what are the cases and what are the things we need to bring about them. We don't have the expertise to monitor their health and safety. We don't have the relationships with the federal bodies that they're the only other entities that oversee them to effectively protect the safety of the public or the safety and well-being of these animals. So I respectfully request a favorable report on this bill that will take that responsibility out of the hands of local government and allow us to do the real work that we need to do every day. Thank you.
I can go next. Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Kim Fullerton. I'm here on behalf of the Maryland State Bar Association's Animal Law Section. I am also an animal law professor, and the zebra case is on my syllabus. We all have seen enough Netflix to know how terrible owning wildlife can turn out. And this is a bill that really brings Maryland in line with what we're seeing across the board and on a federal level. I do want to touch base on this bill is narrowly tailored. So we have the appropriate exceptions for organizations like zoos. And then we're also going to be eliminating a very outdated and unusual provision, which allows people with disabilities to own exotic animals. And anytime we mess with the law in terms of what people with disabilities have access to, we want to look at it very carefully. And I want to commend our sponsor. This bill is completely appropriate. I believe it's been thoughtfully considered to avoid any unintended consequences. And it brings us in line with the Americans with Disabilities Act as well. So under the ADA, only dogs and in very limited circumstances, miniature horses are permitted to be service animals. So none of the animals that you're seeing on the list in this bill are ADA service animals. So I would just want to assuage any concerns you might have about that provision. This is a great bill. I echo the comments of my panelists, and I'm available for any questions.
Thank you. Yeah.
Yeah. Good afternoon, Chair, Vice Chair, and members of the committee. My name is Leah Shawakana, and I am a student who is concerned about the prevalence of wild animal trafficking and the unethical treatment in sales, distribution, and by unqualified caretakers of exotic animals. This bill addresses a critical gap in current law, and while Maryland already prohibits private ownership of many wild animals, existing exceptions have allowed animals like kangaroos and zebras to be privately possessed, bred, and traded. These animals are not domesticated and their needs cannot be met safely or humanely in private settings. From a public safety standpoint, these animals also pose risk to communities, first responders, and animal control officers who are often unprepared to handle escapes or emergencies involving these exotic species. Yet they are available for purchase as easily as you might buy a new electronic, and in some cases even easier. So I personally have experienced how easy it is to buy one of these animals and have it seemingly shipped not as an animal or a pet, but simply as an object. And in my written testimony, I've included a few websites that I found to be shipping the mentioned animals directly to Maryland without any restrictions. And these sites feature third-party breeders who do not state their credentials, investigate purchaser credentials or intentions, and make buying a wild living animal extremely accessible. And some breeders will ship to any state, and not all are experienced in licensing or policy related to legality. But will ship to any buyer, quote, under their own risk. And this bill takes a responsible approach that prioritizes animal welfare and public safety without punishing responsible rescue or conservation efforts. And at its core, HB 53 recognizes a simple truth. Wild animals belong in environments designed for their needs, not in a Maryland suburb. So strengthening these protections align Maryland law with science, ethics, and common sense, and I respectfully urge a favorable report on this bill. Thank you.
Thank you. Delegate Simmons.
Thank you, Madam Chair. Thank y'all. Thank you, Delegate, for bringing the legislation. Can you talk to me a little bit about the atmosphere in which this is taking place? So is this in a residential area, commercial? Does this apply to like small farms, things of that matter? Where are we seeing this at here in the state of Maryland?
Okay, thank you for the question, Delegate Simmons. So the bill does grandfather private owners of these species, the ones named in the bill, as long as they own them, I think, prior to the effective date, I believe, of October 1 of this year. I think that Ms. Volodin and others may be able to speak to how widespread this is. You heard Ms. Volodin say that the sort of trade in the breeding and the sale of kangaroos and wallaroos and wallabies has sort of exploded. I think she has maybe more specific information, statistics she could share. But I would just say she told me about the case of the, which was relatively recent, I think, of the property owner in Anne Arundel that has a kangaroo that the person keeps in their backyard. So I don't know if that answers your question about how widespread it is, but I think Ms. Volodin could speak in greater detail than I could about that.
Yeah, if she could, I would appreciate it. I'm still unclear.
Sure. Thank you for the question. So part of the problem is these animals aren't regulated. They're not regulated at federal level nor within the state. So we don't have exact numbers for you. I can give you a lot of detail. Please cut me off if I'm going into this too much. What I can say is there is a direct correlation between animals that become popular in the interactive exhibits that you have, such as, essentially an encounter with, say, a kangaroo. So when the public comes and there are a certain number of docile kangaroos, say, they then, for some reason, think, well, that one or two kangaroos that were put specifically at this exhibit are now, I'm convinced I can own one. So what we can say is in the last decade, there were 2 registered kangaroos within the state at the facilities that have to register, USDA Class A, B, or C facilities. A and B are the breeders and sellers of animals. So they went from 2 to now there's over 34 the last time we checked. So even that part is, occurring within Maryland. There is a kangaroo breeder within our state. They would be able to keep their kangaroos should they choose. They do not exhibit them, they simply sell them at auction. They would be able to keep their personally held kangaroos, but they would not be able to continue to sell. I can say that these animals are kept from the news articles we see about their escapes, things like that. It is people in general, what you would normally label as a suburb, are keeping them in large propertied suburbs. They're not building anywhere near the appropriate enclosures, which there's a reason why at a zoo, you have architects that are specialized in designing each habitat because they are able to address the needs of those animals and the safety concerns, keeping them within. Your average person that is buying a kangaroo online is not able to construct that. So they have been kept in literally barns.
Thank you.
So that seems to be the general trend, but I don't want to say that's everybody, of
Sure,
course.
thank you. Thank you, Delegate.
Just briefly, I don't understand, I like kangaroos. They're so cute when they're babies. Wallabies the same. I don't understand what the attraction is if it's 6 feet and, in a way, and then also confining them because we don't even know if they're domesticated in the same way with the zebras. So do you have an idea what the attraction is, why people are doing this?
I absolutely do not. And the way, the reason I got interested in this issue, as Ms. Volodin said, is that I was on the Prince George's County Council for 8 years, from 2010 to 2018. But when there was that escape in 2021, I think like most people, I was shocked. And my response was, what is a private individual doing owning zebras anyway? Not realizing that there was no law preventing that gentleman from doing so. And I am told by Ms. Crooms that he does still own, I don't know if it's dozens or more, and is still in operation even after that, terrible escape. And so that's what got me interested. And then by reaching out to formerly Humane, now Humane World for Animals, and asking about addressing the issue of the zebras, then I learned that kangaroos and wallabies have become a growing problem, growing in popularity and in ownership. Except to say that, to echo what Ms. Volodin said, I would have to assume that these experiences that people are having, where you get to be up close with, a kangaroo, and then people are misjudging and thinking, oh, they seem docile and friendly and whatever, that I too could own one. And again, there's nothing right now in the law stopping them from doing so.
Thank you, Chair. Thank you, Delegate, for bringing the bill and panel. So is the difference between a horse and a zebra that the horse might be registered and regulated and the zebra is not? Would that for anybody on the panel?
A horse can't breed with the zebra, so they're completely different animals.
I asked about regulation.
Oh, just the regulation.
I understand breeding.
Okay, gotcha. Yeah, so a horse is regulated, well, it's agriculturally regulated in the state, right? The wild animals are not regulated at the state level. They are, other than the bans that you have passed, they are regulated at the county level. And so our responsibility as a local government is to regulate wild animals. So then we would have, in Prince George's County, there's the requirement that you register that the animal generally these folks have more than one animal, so they would be registered also as a facility that's housing animals. But all of that occurs at either the municipal or the county level in the state.
Okay, are there exemptions for slaughterhouses?
I'm not aware of an exemption for slaughterhouses. I'm also not aware of these species being slaughtered on a commercial scale.
Well, just because you're not aware doesn't mean it doesn't happen. And October of 2019, a 1,600-pound Angus bull escaped for a couple hours in Baltimore City, so that was a very dangerous creature also. Wouldn't you agree?
I agree, and I believe that we had the legislation in place to make that a more safe situation. And just to highlight another case where the established law really came into play and helped us as a society was just a few months ago, within the past year, there was a gentleman keeping an alligator, one of the listed species on this established legislation, in his apartment building and walking it down the sidewalk on a leash. And so because we had this bill, because this was in place, we were able to take action on that.
Well, we're getting some feedback over here, but some people have hybrid dog wolves. I've seen those in Baltimore, and I know that they're supposedly being illegal, right? Is that correct?
I believe it depends on the species. You know, I don't have exact information on a wolf hybrid as it relates to this bill, but my understanding is
okay.
No.
All righty. Well, you can look into Rob's report and buy one, but thank you very much.
I don't see any other questions. And that concludes this panel. I believe that Ms. Shiwakina, was she here today?
Yeah.
Okay, great.
Yeah, and is Ms. Radoff still?
Yes, I was going to ask if Ms. Lisa Radoff is here.
She's virtual, right?
She's on Zoom. Okay, great. Well, she can come into the room.
There she is.
Hi, Ms. Radoff. Whenever you are ready, you can begin your testimony for 2 minutes, please.
Fantastic. Good afternoon, Chair Bartlett, Vice Chair Davis, members of the Judiciary Committee. Thank you for the opportunity to testify virtually before you today. My name is Lisa Radoff. I'm the President and Chair of Maryland Votes for Animals, here in support of HB 53. You've already heard extensive testimony from the expert panel about this bill, as well you also have my written testimony, so I will be brief. Essentially, this is an issue of protecting the public from injury or even death from these wild animals, not to mention destruction of private property. Expanding Maryland's law banning private ownership of wild animals to include zebras, kangaroos, wallaroos, and wallabies will help law enforcement as well as protecting communities. Essentially, zebras, kangaroos, wallabies, and wallaroos are not meant for social media pictures and should not be pets. In closing, I would like to thank Delegate Lehman for her sponsorship of HB 53 and urge this committee to give this bill a favorable report. Thank you.
Thank you for your testimony. Members, do we have any questions? Seeing none, that concludes the testimony for House Bill 53. Thank you very much, Delegate. We're going to move on to Delegate Simmons. House Bill 95. I'll get you next. And members, if you've ever had any questions, this is the time to ask them all.
That's it, that's it.
Okay, Delegate Simmons, the best clerk in the world, Scott Poyer from Anne Arundel County, Michelle Smith from MSBA, and Heather DeWeese from Circuit Court Clerks Association. I don't see Michelle Smith. Is she still going to testify? Okay. Do you want to? Okay, if she's going to testify. So Delegate, oh, here she comes. So Delegate Simmons, whenever you're ready.
Thank you, Madam Chair, and distinguished members of the Judiciary Committee. Gary Simmons on family law marriage license applications, appearance in court. As you know, this is brought by the clerks of the state of Maryland as they looked at some shortcomings when it came to the process in which they deal with applications for marriage, where they were seeing some fraud that was taking place in that space. And this legislation is set to correct that fraud by looking at some adjustments coming out of the clerk's office. They have also had the opportunity to look at and entertain some amendments to it. I think you should have the amendments by now. If you're not, we will get you a copy of the amendments. If there's any questions in reference to the amendments, the clerk's office is here to provide any testimony on those amendments as well. I would like to, in the interest of time, my statement is on file. I would like to turn it over to the clerk's office for further testimony. Thank you.
Thank you, Chair Bartlett, Vice Chair Davis, and members of this committee for the opportunity to testify in support of House Bill 95. For the record, my name is Heather S. DeWeese. I am the clerk of the Circuit Court for Carroll County. I'm also testifying on behalf of the Maryland Circuit Court Clerks Association. I support this bill because fraudulent marriages promote identity theft, property theft, and federal and state benefit theft. In my own county, there was recently a case where a woman obtained a fraudulent marriage license and used a fraudulent officiant signature to assert the marriage had taken place. After a marriage certificate was issued, my office found out that the other party on the marriage license was deceased. My office had no way of knowing because only one party must appear for a marriage license to be issued in the state of Maryland per Maryland statute. The woman is now currently under investigation for fraud. There have also been allegations of an ongoing marriage fraud operation in a Maryland county involving foreign parties marrying U.S. citizens, which is currently being investigated. This situation involves multiple marriage licenses where only the foreign party is ever seen. Neighboring states and most of the East Coast, such as West Virginia, New Jersey, Pennsylvania, require that both parties are present and show government-issued ID. However, a clerk in Maryland may never see the other party to determine if they are being coerced into marriage, underage, or even aware that a marriage license has been issued in their name. To give you an example, per se that I obtain our sponsor, Delegate Simmons' driver's license. I can then apply for a marriage license, receive it after 2 days, and then forge an officiant's signature, and then return it back to my office, and we would be married, and he would never, ever, ever know. But he would be happy. Yes. This bill adds a requirement that both parties appear before the clerk, which brings Maryland up to the same standards as the other surrounding states on the East Coast. It will reduce fraudulent marriages, and it will thwart potential human traffickers from obtaining marriage licenses in our state. I ask for a favorable report on HB 95, and I would like to thank Delegate Simmons for being our sponsor. And if you would like, thank you for the opportunity to comment. If you have any questions, please feel free to ask.
Thank you, Chair Bartlett and members of the committee, for this opportunity to testify in support of House Bill 95. For the record, my name is Scott Poyer, Clerk of the Circuit Court for Anne Arundel County. I'm also testifying on behalf of the Maryland Circuit Court Clerks Association, representing the 24 elected clerks in the state of Maryland. The clerks of the Circuit Court support HB 95 because the clerks are responsible for issuing marriages in the state of Maryland, and we need additional tools to fight marriage fraud. As my colleague, Clerk DeWeese, testified, marriage fraud is an ongoing problem in Maryland, which this bill would help address. One issue we have discussed among the clerks and with other organizations is whether the proposed requirement that both parties appear in the clerk's office sets too high a bar for marriage applicants. To address this concern, we have worked with sponsors on amendments, with the sponsors of the bill on amendments to the bill to allow waivers for deployed military members, incarcerated individuals, hospitalized individuals, and other exemptions for good cause. We believe this will allow for situations where one of the marriage applicants cannot legitimately appear in the clerk's office, yet still would be a significant improvement over the current requirement that only one applicant ever needs to be seen. I ask for a favorable report on HB 95 with amendments that have already been submitted by the sponsors, and I would like to thank Delegate Simmons for sponsoring this bill. Thank you. I'm available for questions, Madam Chair.
Thank you. Ms. Smith?
Thank you, Madam Chair, and esteemed members of the committee. I'm Michelle Smith here on behalf of the Maryland State Bar Association Family Law Section. We support House Bill 95. It's a no-brainer. We initially had some concerns with the drafting, but they have all been addressed in the amendments. So the amendments that I believe you have before you, we fully support, and we thank everybody for working together on those amendments. I think it makes it a strong bill. As we all know, the marriage contract is one of the most important in our society, and it only makes sense for the clerks of court who are issuing these licenses to be fully satisfied that no one is being induced, coerced, there's no fraud, the people are alive, the people are of legal age, and I'll just put a carrot in that, we should raise the age for marriage, but they're of legal age to be married, they are making a knowing and voluntary contract, just like all other legal contracts. You can get a license to drive a car, you have to be in person. You should be in person to get a license to be bound to another human being in a legal contract permanently, in some cases. So we support a favorable vote on HB 95. Thank you.
Thank you very much. And I have a question for the best clerk in the world, Scott Poirier from Anne Arundel County.
That's for me, right?
Yes, you all are wonderful, but
Chair is too kind.
but Mr. Clerk Poirier is just, you know, he's from Anne Arundel County, so. I wanted to ask you about I thought I saw in your testimony, along with the amendments, an exemption for good cause. And so I kind of want you to flush that out a little bit. Is that something that would perhaps go to the clerk and say, you know, by letter, or is there what's the manner in which someone would explain or believe that they have good cause and assert it to the clerk?
Thank you for the question, Madam Chair. We added that as a
catch-all.
As a catch-all, really, for anything where there was something where they weren't a member of the military, weren't incarcerated, or weren't in a hospital, but still had a good reason. And so right now, we can't even ask questions. Only one person, under the current statute, only one person needs to apply for the marriage license. With the catch-all, we think it would cover any unforeseen circumstances as well, where a person just couldn't make it in. If they can answer our questions to our satisfaction, and exactly right, it goes to the clerk, and if the clerk is satisfied that the person's not under duress, so on and so forth, then we would grant the license.
And to add to that, one example could be if somebody was in a job where they were overseas and could not leave the country and were going to be back later on. And in this particular instance, we would be able to assist that person with getting the marriage license.
And so the prerogative is basically with the clerk on determining the exemption for good cause. Okay, thank you. Yeah. Thank you. I saw your head
Yes, Madam Chair.
Thank you very much. Questions for this panel? Delegate Conaway?
Chair, thank you, Delegate and panel, for coming in to testify. So, Delegate, when did you submit your amendments? Because they're not on our computers.
The amendments I have before me, they should have been submitted earlier in the week.
Early in the week, okay. We look forward to getting a copy of those amendments.
Are they not reflected?
They're not reflected. We only have them in testimony. So
okay.
When you receive it, if you could send it
right away
to the committee.
Yep.
Thank you.
Okay. Do you need 2 days to, I guess, generate the marriage license, or can the two individuals come the same day and get the license and get married the same day?
No, sir. They cannot get married the same day per Maryland law. There's a 2-day waiting period.
And that's in current statute.
I understand that, but if you have both people there, is there a reason you'd like to offer as to why two people that show up cannot get married the same day if they attest that they would like to?
There is an exemption in statute, but it has to go before a judge. So if for any reason, so right now there is the requirement, there's a 48-hour waiting period. If they have good reason, and members of the military, I've done this for members of the military in my own courthouse, we have to send it to a judge, and if a judge approves, then they can get the waiver and get married before the 48 hours. But that's
most likely it won't be the same day.
No, I have done it on the same day.
You've done it on the same, yeah.
I have done it.
I'm aware that you can do it, so thank you so very much.
We also say it's just to make sure they don't change their minds.
No.
That was a joke, sir.
No. Well, I don't think it's very funny because my dad used to be a clerk of the court, so he took it very serious.
Yes.
Very
Well, we do. We wait the 2 days, but it is, we have had people change their minds. We have multiple marriage licenses that don't get executed.
You gotta go to Vegas, right?
Right, that's true.
Thank you.
Costs more money, though.
Delegate McComas.
Real quick, what happens if they lie under oath? Okay, no, I mean, is there a penalty that if it comes out later on, let's say they say, okay, I'm going to get married to General Washington or something, you know, he's a big buck guy, and then General Washington keels over, but they weren't married, and then somebody says, hey, he's not, you know, and then they try to collect all the money. In other words, is there a way that they're going to get torched because they lied on the application?
They would be subject to perjury. There is in the application, in both the application and the affidavit that we use now, they swear to it under penalty of perjury. That if they're, and it's also a case where the marriage may, oh, I'm sorry.
Is there a thing, because not everybody knows the federal, or not the federal, but the criminal law penalties. So is there anything on that? Because I've been married for a while and I can't remember what I signed, to be honest with you.
Did you perjure yourself?
Yeah, no. But I just can't remember what it looked like because we both went in. I mean, you know, but the bottom line is what, in other words, do they know what the penalty is? It's that it's a year or 10 years or whatever for the penalty of perjury.
And there's a reference to it in the for saving on space, we just provide a reference to it that they swear under penalty of perjury that they're not lying.
But people don't think perjury's a big deal anymore. You know what I'm saying? That you could get like maybe 10 years, 5 years, whatever it is. I just think maybe that might be something you consider as because there is a lot of stuff, because we had some hearings about, which delegate here was also about all the fraud on the deeds, which is scary as heck. So I think, you know, they're going to figure out every way to get a dime off of somebody for free.
And it is also possible that the marriage would not be considered lawful as well if they lied about or brought in.
Right, but, you know, it's just maybe that would give them a little bit of pause, I would hope. But
In the particular instance in our county, one of our circuit court judges annulled the marriage. And there were attorney fees that the family of the deceased party had to pay because of going to court. So that is another problem. You know, for example, Delegate Simmons would have to get an attorney and pay money as I went out and tried to get particular benefits of being married. If I actually took his driver's license and applied for that marriage. And this was a real issue of concern in our county. It took a lot of time from my office because we spent a lot of time and manpower on making sure that, you know, everything was covered, and it took away time from doing other business.
Oh, sure.
So it's just one of those things where it's such an anomaly, but it's a scary one.
Thank you. Delegate Boucher?
Thank you, Madam Chair. I want to express my sincere appreciation for my clerk of the court coming in and weighing in and telling how important this is for us and how it affects the criminal system. My question is to Delegate Simmons. Is your marriage license valid?
You know, I did notice that the clerk here in Anne Arundel County talked about fraud, and I will say he did sign my marriage certificate. And I do have Delegate Congo that was part of my wedding team, so she was a witness.
All right, good.
Yeah.
Well, good question, though. Okay. Thank you very much. That concludes the testimony for this panel.
We have another question.
Oh, I'm sorry. I thought you had lit it, and then I thought you had turned it off. Sorry. Okay.
Kind of something that crossed my mind because, well, for one, you know, I got married, it was 24 years ago, actually in the state of Maryland. I lived in Delaware. We chose Maryland because it was an easier state to get married in. So anyway, but I just have a question because I know often when we talk about ID requirements, you know, people talk about it's discriminatory in nature. It, you know, creates issues and disproportionately affects marginalized groups, you know, people with, you know, low income who may not have an ID. I mean, what are your thoughts on that argument being made when we talk about other issues regarding ID requirements?
The ID requirements that we've got in right now, it is left to the clerk's discretion. There have been instances where the person didn't come in with a driver's license, you know, an accepted one, and we've asked them to bring in other forms of ID, and if they can show to us, they can, and again, it goes back to the clerk's discretion. If they can show us other documentation that would assuage any issues that we've got, then we could grant the license.
Okay.
Most people bring it in. I would say 99% of the people are bringing in a driver's license or other accepted form of ID, passports.
Okay, so you see that most people do have a valid ID?
Most do.
Okay.
Your same experience with you?
Yes, we have had minimal issue with that, but we would do the same thing. Also, what we find is our biggest concern would be the age of the applicant. If we, you know, obviously with one party, if we can't see the age, but if both would come in and the age of the party would seem young and they didn't provide an ID, then yes, I would definitely have additional requirements made and be very skeptical of that situation just for protecting the younger party.
Right. So it sounds like you recognize that having an ID reduces the risk of fraud. You're able to identify the person's, well, their identity. And your goal here is to make sure that there are no illegal or fraudulent marriages. And in doing that, having a person present in person with an ID will reduce fraud.
Yes, ma'am, and also human trafficking. This is obviously something we're very passionate about in the state of Maryland. So to thwart any of those particular opportunities, and we do, as I mentioned, have, because it is easy, people from other states are coming down, and there is a current investigation, a federal investigation involving multiple parties, multiple marriage licenses, where they're human trafficking young women.
Okay, all right, thank you.
Thank you. Now that concludes the testimony and the hearing for House Bill 95. Thank you, Delegate.
Thank you.
Thank you.
We're going to move now to Delegate Taylor. House Bill 142. And, yeah, we'll do House Bill 142. And I have an indication that all right. Dawn, do we have Dewan Burton? Christopher Dews and Dan Hatcher? And April Hamilton.
Hi.
Do I have a quorum? Do I have a quorum still? I'm about to lose my quorum. We're in recess for a moment.
pictures of these zebras.
We are resuming. We are now going to start the testimony for House Bill 142. Delegate Taylor, whenever you're ready.
Thank you, Madam Chair. Good afternoon, my favorite committee. And my only committee. For the record, I'm Delegate Kim Taylor, representing Prince George's County's District 23. House Bill 142 proposes to cap wage garnishments at 25% for child support obligors that earn less than 250% of the federal poverty guideline. And that translates to about $40,000 a year. The objective of this bill is to improve a low-income person's ability to pay his or her child support orders and remain in the workforce. Last year, this proposal was the highlight of DHS's Omnibus Child Support Reform Bill. And this year, we are making it a standalone issue. This policy began with the 1968 Federal Consumer Credit Protection Act, which caps disposable income wage garnishment at 25% for most debts, but permits wage garnishment up to 65% for child support and alimony obligations. As an example, a worker earning Maryland's minimum wage of $15 an hour is left with only $4.25 per hour, or about $4.25 per hour, or about $8,000 annually after taxes and a 65% garnishment. To be clear, this bill does not mandate child support orders. What it does is amend existing law in a way that encourages obligors to continue to work, remain accountable for supporting their children, and have enough funds left over to cover their own basic living expenses. I urge my colleagues to vote favorably on House Bill 142, and we have an expert panel here to address any of your hard questions. Thank you.
Okay, now I'll go first.
Okay.
Christopher Dews.
Expert panel. Go
Indeed. Love being an expert. Christopher Dews here representing the Center for Urban Families. Center for Urban Families is a workforce development program in West Baltimore, District 40 specifically, that is all about strengthening families and ensuring that they have economic access and ability to take care of their children. So Center for Urban Families worked very closely with DHS last year on this piece of legislation, as well as Professor Dan Hatcher. This was language that was added in one of DHS's amendments, as was mentioned, and the whole mission was to ensure that we distinguish between dead broke versus dead beat, and individuals that we've discovered that make less than $40,000 a year, when we would get them access to opportunities, and specifically employment, once they got their first check, we found that retention rates became very, very low with regards to their jobs, with high levels of turnover, because once they lost 65% of their check, they did not have the means to survive on or the means to go on working. And so we want to ensure that individuals stay working, that they stay employed, that they stay taking care of their children, and this piece of legislation is designed to do just that. As it was mentioned, or I don't know if that actually was mentioned, this was a recommendation in an ABLE Foundation report from 2019 from the former federal chair of child support. The mission being, again, and I believe the exact language that was written was the 50 to 65% withholding rate could have the unintended effect of pushing low-wage parents out of a job because the remaining paycheck is too little to survive on. And there was more research that said that child support is more likely to be paid if it consists of roughly 1/5 of an obligor's income, and collection rates decline when support orders comprise more than 30% of obligor's incomes. So that's the reason why, for this specific population of those making less than $40,000, to ensure that there is an increased amount of compliance and payments, and to ensure that there's an increased amount of participation in the workforce, that we are trying to cap the garnishment for just this population at 25%. For those reasons, I urge a favorable report. Thank you.
Okay. Good afternoon, Chair, Vice Chair, and members of the committee. My name is DeJuan Burton. I'm the Deputy Director for Out for Justice. I'm also a resident of District 32. And Out for Justice is a grassroots organization to engage, educate, and empower individuals impacted by the legal system, and we actively hire staff and members on child support who have direct experience with 50 to 65% of their wages being garnished. We strongly support this bill, which caps garnishments at 25% of disposable income for lower income parents. Let's be clear, it's really not disposable. I think that's a myth. It's the income that they have from working a job. As an employer committed to hiring from impacted communities, I've seen firsthand how excessive wage garnishments affect employee morale and job retention. When more than half of an employee's wages are taken, meeting basic needs becomes nearly impossible. Our members question why they should remain employed full-time when their wages cannot cover rent, food, transportation, childcare, which leads to disengagement, absenteeism, and in many cases, quitting work altogether. We invest significant time and resources in recruiting, training, and supporting our staff, particularly those rebuilding their lives after incarceration or long-term economic hardship, only to have them leave after their first or second paycheck due to wage withholdings. Thus, we have to repeatedly recruit, onboard, and train new hires while managing staffing gaps and reduce productivity. Reducing the garnishment cap to 25% for lower income workers who make up the majority of our member base would be a boon to our business and reduce turnover. For these reasons, Out for Justice respectfully urges a favorable report on this bill, and I'm happy to answer questions on the new hire process. Thank you.
Good afternoon, Chair Bartlett, members of the committee. Thank you for the opportunity. Thank you for our wonderful sponsor. And it's an honor to be here with Out for Justice and Center for Urban Families and to work alongside them. This is an incredibly important bill. I'm a law professor at the University of Baltimore, where I've been teaching since 2004. I teach a variety of classes, including a clinic where students represent low-income clients in all poverty-related issues. Prior to that, I was a legal aid attorney where I represented both custodial parents, non-custodial parents, and children, including children pulled into the foster care system. I was also a senior staff attorney with the Children's Defense Fund. I've been doing research on these very issues for over 20 years. And I can't overstate how much harm is happening right now to low-income communities and all communities because of the current practices. This bill is common sense reform that is desperately needed. It will benefit children and custodial parents by increasing child support payments and increasing the consistency of child support payments. It will benefit non-custodial parents by helping those who want to pay actually be able to pay and then actually still be able to eat, once in a while, right? If you think about 65% garnishment, if you're working $20 an hour job, you get hit with that garnishment, you will quit. I would, right? That's the situation that you're facing. This will benefit Maryland businesses, as we already indicated, right? Because they will be able to keep their workforce, right? The bill will benefit the child support agency. It will help in their ability to carry out their enforcements. Their numbers will look better. They will get higher federal 4D funds from the federal government, right? It'll increase revenue, which isn't accounted for in the fiscal. It'll benefit all of us. The Maryland Department of Human Services has already supported this very language in this bill, right? This exact language. I want to stress that Vicki Turetsky, who is the head enforcement officer in the nation, supports this language as well. And I'd welcome any questions. Thank you.
Thank you. So let's talk about the elephant in the room, the fiscal note.
Yes.
Let's talk about the fiscal note.
Yes.
It looks like there is some offset with respect to federal fund matching, but it still looks like the net effect is going to be 1.3 million for the first year, and then about, I think this is $500,000. I don't know. Is it $500,000? About $1/3 Do we have any thoughts, ideas? And was it this large when the department was bringing this idea?
No, it was not.
It was not?
It was not.
Okay.
Yeah.
Interesting.
It was a fraction of this. If you look at their bill, which was SB 195 and HB 218 last year, which didn't just include this, but multiple issues, a fraction of this.
Okay, give me, I know I can look them up, but just to make it easy, SB 195 and which one?
HB 218 from last year.
218, okay.
And I believe, I want to say it's amendment number 4 on page 6 that this, that we have in their testimony from last year. Yeah, now I will also say that we are working with the department on some amendments. I know that there were conversations as to the, like the knowledge of how much the income, how much the individual will have via income. And so last year, this committee helped gladly pass legislation around license suspensions. And one of the provisions in that was that the court shall give to the Child Support Administration, and Mr. Pastor Hatch, you can probably say the language more specifically than I can, the income information, basically. So we are willing to work with the department to kind of alter like the starting point. So basically, if after October 1st, 2025, in which the department will then have access to the individual's income, so that way they can make the determination a lot easier, we are willing and open to having this bill go prospectively. And for the individuals in the, before October 1st, 2025, before DHS, we know without a shadow of a doubt has that income, then we're willing to have that individual bring their income statements, as we did with the license suspension bill, to the DHS so they can have that conversation there. That was one.
Okay.
I know, sorry.
No, that's fine. I'm glad you got that on the record. So that's what I think is a first step that needs to happen, because on the fiscal note, it is rather high, and it is going to need to go down so that we can consider it.
And those discussions start tomorrow. I have a meeting with DHS tomorrow.
Great, perfect. Members, any more questions? Delegate McComas?
Just a real quick question. Assuming that the obligor is not as wealthy as, let's say, the person that's getting the money, the mother, let's say, you know, dad's pay, and mother may take the tax exemption on the kids. That ought to be figured into this, and I know that's probably going to start a war, but the point is that, you know, if dad's living on a very low budget income and he wants to have, you know, a meaningful time with the children, and then mom's, you know, getting every dime and she's maybe not working or, you know, in a better position or remarried or something. So, I mean, you kind of, all those little equities ought to be kind of filtered in. And I mean, it makes it a lot more complicated, but I just think that sometimes there could be a war over who gets a deduction with the kids on the tax returns.
I can speak to that, just simply saying, I know this is, of course, one piece of a very, very large pie that of, let's just say, some troublesome law. And so we're just trying to focus on the earnings withholding for this specific piece. But I want to say there was a piece of legislation last year that we had conversations with the delegate on looking at that specific provision. So I do think there are conversations happening, but we are trying to keep that issue as one and then this wage garnishment issue as one. Yeah.
Strike at one point, but I do, my concern is that, you know, the person's got to have some point of living, or they're also just going to go underground and, you know, untaxable economy or whatever, and it just
hurts everybody.
Yeah, I mean, it's a problem.
And that's what we're saying.
I think they're great comments and questions. Next year is a quadrennial review, and there'll be opportunity to look at all the issues with child support order establishment, right? I think that would go along with that potentially.
Thank you.
Thank you for the question.
Great. Delegate Valentine?
Thank you, Madam Chair, and thank you, Delegate, for bringing the bill, and good to see the panel today. I just wanted to expand on the fiscal note a little bit more, and I think Mr. Dews brought it up about the discrepancy of last year. In your research or from looking at last year's bill, I'm looking at the number of individuals they think need to be hired for this, and there is a wide gap of what one is saying nearly 10, or one could be as many as 30. And I was wondering if what last year's looked like, if you remember that, or was it in their bill last year that they would need another 29 or 30 employees?
I believe it was in their language from last year. I also, if I recall correctly, during their budget hearings, there was also a call for more staff. So I do believe that, just genuinely speaking, that's regardless of.
Maybe that would have been for the entire bill and not just specifically for this component?
Possibly so.
Can I clarify on that
yes.
too? Because also last year, the license suspension bill that went forward and was enacted, their number of employees and the cost was, I think, virtually the same as what they're saying for this bill. That bill has already been enacted.
Correct.
Right? You know, like, so you don't get that, you don't get to double dip with it. Like, so yeah, it's an inaccurate fiscal note.
in your opinion, because that component was already enacted, that number should have gone down with
Yes.
that number of employees?
Yes.
Thank you. Yeah. Thank you, Madam Chair.
Thank you. Members, does anyone else have any questions? Seeing none, that concludes the testimony with this panel. We're going to move on to our next panel. And it looks like everyone is online. Is April Hamilton online?
She should, yes.
Okay. And Jonathan Williams? He is not. Okay, well, we will start with Ms. April Hamilton. Ms. Hamilton, whenever you are ready, you may begin with 2 minutes testimony. Thank you.
First of all, I'd like to thank you all for allowing me the opportunity to testify in support of this bill. I'm April Hamilton, a solo mother of 2 children living in District 8. I'm an obligor and a recipient, giving me the unique perspective on how this system actually functions for families like mine in real time. Today, my arrears are around $18,000 and my wages and taxes have been garnished for nearly a decade. I want to express deep gratitude to this committee for passing last year's license suspension bill. Because of that bill, I was able to regain the privilege of having a driver's license. While that reform has helped to improve my circumstances, the wage garnishment system remains structured to make it nearly impossible to get ahead. For years, I worked as a server, 6 days a week, often 12-hour shifts or more. I was working nonstop and still couldn't make ends meet. I would stand at work trying to think of how my budget and bills versus my income could work. No matter how much effort I put in or how many excellent tips I got, the numbers never worked. The harder I worked, the deeper I fell. My arrears continued to grow, and it felt like there weren't enough hours in the day to get out from under the debt. Even when I didn't have a car or driving privileges, I went to work. I walked 8 miles a day to get there. The wage garnishment continued, and after rent and basic expenses, I could barely afford food. I survived with the financial support of my family, but I continually worry about what happens when they're gone and never being able to reach independence, let alone to afford legal help to address custody issues with my children. Under the garnishment system, there's no real path out. When the levels are too high, the arrears grow instead of shrinking, and work starts to feel pointless. When you're making about $1,600 a month and your rent is supposed to be 25% to a third and your largest expense, and then right behind that, you have your child support, which is sometimes, a third or more than 25% of your income, it doesn't work. Senate Bill 16 would change that for me. I want to be financially independent and have hours in the day to pursue further education and therefore a better income and more stability for my children. For these reasons, I urge a favorable report, and I'm happy to answer any questions you might have.
Thank you. And are there any questions, members? Seeing none, thank you, Ms. Hamilton. We're going to move on to our person testifying in opposition, Mr. Brendan Madden, if he's online. He is not online. Therefore, I'm here. Oh, you're here. You're in person. And it says in person. And it says both, so that's why I wasn't sure. Okay. All right, Mr. Madden, I'm glad you spoke up. Feel free to begin your testimony whenever you're ready.
Thank you, Madam Chair, members of the committee. My name is Brendan Madden. I'm here representing the Family Law Section Council of the Maryland State Bar Association to express our opposition to this bill. In Maryland, child support is fixed in the child support guidelines. That's sort of the framework we follow. We have a well-established body of law. And it has its problems, but those are the laws that we've built on and amended time after time. And those laws rest in the judiciary. And it rests in a determination of the parent's actual income. And actual income is based on a broad set of, it's any income. If you look at the definition, it goes well beyond what this more narrow category of disposable earnings is that's going to be in place for garnishment. And when we impose a cap on a garnishment downstream from the judicial proceeding that imposes child support in the first place, we're running the risk that we're we're creating this more narrow band, and we're not actually collecting on the child support obligation that's ordered. We're putting in place this situation where these obligors are actually developing an arrearage almost by default if the garnishment is less than the amount of their obligation. And it's preventing an opportunity for the obligee to be heard, and for the needs of the child to be represented fully, because we're taking from an adjudicative proceeding, the trial, the court proceeding where the obligation is fixed, and we're shifting down to this automatic imposition of a garnishment cap by a state agency that no one gets to, none of the antagonists to that initial proceeding have a say. We're worried that it's going to interfere with federal guidelines on child support. We are very concerned about what is in this fiscal note. And it really, in summation, we're worried that, this path is fraught with peril. There's a lot of unknowns to this. And our urging would be, if nothing else, this should await next year's quadrennial review of the child support guidelines before we decide whether to impose this very low cap on the main collection mechanism for child support in the state of Maryland.
Thank you. I have a quick question. Okay, so I just made a note for myself to ask you about the how the bill creates on disposable income earnings, a different and more narrow standard from the Consumer Credit Protection Act. And you might have actually just answered this question. I didn't understand what you said. So that's why I'm asking you if you could expound. Okay.
So I didn't, what I was referring to was the difference between actual income as used to calculate child support by the Maryland Circuit Courts. And that is what is defined under Maryland Family Law Article 12201. Earnings and disposable earnings, and those are terms from the Consumer Credit Protection Act, federal law, and there's a parallel definition of at least earnings right now in Maryland law under Family Law 10101. The concern for the MSBA, as articulated in the written testimony, is the disparity between actual income under 12201, which is very broad, and this new definition of disposable earnings that's going to be implemented under the proposed bill, which is more narrow. And so we're going to be capping income for garnishment under a more narrow definition than we're using to actually set the child support obligation in the first place. And that is a concern.
I appreciate that explanation. Members, do we have any other questions? Seeing none, that concludes the testimony for unfavorable for House Bill 142, and that concludes the bill hearing for House Bill 142. We're going to move on now to Delegate Vogel for House Bill 134. Good to see you, Delegate. How are you?
Good to see you, Delegate. Madam Chair, and a pleasure to be here in the Judiciary Committee. I don't come here often, so you know it's important. House Bill 134 really started from a conversation I had with Brenda, who's here today to share her story. The House of Delegates passed legislation in 2018 to address the issue of visitation for those under guardianships. And the House passed it in the form that I'm introducing it today. And the Senate did what the Senate does. And the bill was weakened pretty significantly just to express that it is the intent of the General Assembly to promote visitation with those under guardianship. When Brenda and I met over the summer and had a discussion about what she went through, I was doing my research there on the fly and started looking back at this bill. And as we talked about the way the bill was initially introduced, there was some excitement because it would have been able to help Brenda and those who are in the same situations that she was in. But unfortunately, the bill as it was signed into law does not create this sort of petition process, and therefore does not in practice help those going through these situations. So I really want Brenda to be able to share her story, and I just urge a favorable report on House Bill 134.
Thanks, Joe. Hi, my name's Brenda Daniel, and I want to thank you all so much for listening to me today. And I want to share my mom's story. Her name was Anna Daniel, but she was affectionately called Poochie. Mom was a Puerto Rican native who moved to D.C. at the age of 19 and worked for the federal government. She and my dad had 7 kids together. Poochie was an avid gardener, animal lover, Scrabble champion, and sports enthusiast. In May 2019, Mom was secretly moved from her beloved home of 40 years by her power of attorneys, unbeknownst to me and my brother. She was then living in an assisted living facility. By December 2019, my physically fit mom was prevented from leaving the facility. She was deemed civilly dead. By March 2020, the facility was on lockdown and COVID ravaged these facilities. The death tolls were just horrific for all states, Maryland too. The New York Times referred to them as death traps. Mom pleaded to leave, but her pleas were ignored. The POAs refused to let her live in my safe and loving home. In April 2021, Mom sustained horrific facial injuries, requiring a hospital stay. 2 days later, Poochie was returned back to the deadly and dangerous facility and isolated again. In May 2021, the facility lockdown was lifted. All residents were free to come and go, except for my mom. In July 2021, my husband and I were banned and prevented from visiting my mom. Her personal cell phone was removed, as well as her landline. We had no means to communicate with her. I had been cleared by a judge to visit my mom, but that directive was completely ignored. On December 23rd, 2021, finally the facility relented and allowed me to see Mom. The next day, the POAs removed Mom from the facility. I didn't know where she lived for 17 months. None of us did. I truly didn't know if she was alive or dead. A couple of weeks prior to Poochie's death on June 8th, 2023, I found her via 3 PIs and attorneys. We were permitted to visit supervised 3 times prior to her passing. I hope these civil rights violations and abuses of our vulnerable seniors can be prevented. The separation, isolation, inability to visit your loved one is heartbreaking and excruciating. I wholeheartedly endorse House Bill 134. Thanks again for listening. I really appreciate it. It's a national toxic crisis. Thanks again, Joe. I really appreciate it.
Thank you. I appreciate you sharing your testimony with us. I have a question.
Sure.
That is more of a request, and this is for Delegate Vogel. The judiciary comes in with strong opposition, and I wanted to know if you are working with them or intend to work with them on some of the issues that they have introduced.
Thank you, Madam Chair. I have their letter of information, or maybe it's an unfavorable testimony from them. The first I heard about their opposition was from this letter, so we will reach out and have those conversations and find some common ground.
Great, that's what I like to hear. Members, do we have any questions? Seeing none, that concludes the bill hearing for House Bill 134. We're going to move on to our last bill of the day, House Bill 324, Delegates Simpson and Taylor. I don't know. Let's find out. Are we going to get 2 for the price of 1? Okay, Delegate Simpson. Okay, so we have a panel of Christopher Dews and Dan Hatcher.
We do. We do.
All right. Whenever you're ready, Delegate.
All right. All right, good afternoon. I'm the only one keeping you from dinner, so let's get to it. House Bill 324, which is Family Law Child Support or Assignment of Rights, limits when the Department of Human Services may collect state-owed
child support payments from parents whose children are in foster care. This bill was taken directly from the great big bill of child support DHS introduced last year in 2025. And you will see that the department and many of the family law advocates actually support this bill. We did get a very good fiscal note as well. Just stating the obvious, parents whose children are placed in foster care are already struggling. They often have trouble paying rent, buying food, finding transportation, or keeping a steady job. Currently, Maryland allows the government, almost requires the government, to charge parents child support when their children are placed in foster care. This money does not go to the child. It goes to the state for foster care costs, and it's called cost recovery. So research has shown that cost recovery for foster care actually hurts families. It pushes parents deeper into poverty, and it actually delays children from returning home. The studies show that this practice does not save any money. Actually, Maryland spends more money trying to collect the child support than it actually receives. So in 2022, the federal government told states that charging struggling parents makes it harder, all the things we just said, right? So several states, including California, Michigan, and Washington, already stopped or limited the practice. So what House Bill 324 would do is the same thing in Maryland. It would stop requiring the state from routinely filing child support cases against parents with children in foster care, while allowing these cases to, it will only allow it in, it doesn't specify, but in rare situations. So families involved in the welfare system need support. Children want to return home. Families need housing, they need food, they need transportation. With this bill, we can help families reunite, those families that are able to reunite. Please give House Bill 324 a favorable report. And if you would like, for the record, I'm Karen Simpson, delegate in Frederick.
Good afternoon again, Chair Bartlett, members of the committee. Thank you again. My name is Daniel Hatcher. I'm a law professor at the University of Baltimore. Prior to that, a legal aid attorney, as I described before. I've represented parents and all poverty issues. I was also an attorney for children pulled into the Baltimore foster care system. In my first couple of years there, I represented probably over 300 children within a year, and that experience sticks with me, right? And it's driven a lot of my research over the years, including on this particular issue. I've been writing about poverty-related issues for over 20 years. One of my early law review articles was on this very issue from 2007. It's linked in the article and then scholarship since then I've addressed this. This policy of pursuing low-income families in the foster care system for something they call child support when it's not child support is a horrific policy. It's harmful to everybody involved. It's harmful to the mothers, to the fathers, to the children, to the communities. It hurts the state fisc, as we already heard, because children stay in the system longer, which increases state costs. Also, the cost of enforcement, the administrative costs of enforcement are higher than the collection. So even if you're just looking at it as a purely money question, right, they're spending more money than they're collecting in the state of child support. So it's nonsensical as a bill. So I strongly support the bill. It's consistent with federal law. The language in federal law only indicates that the referrals for child support should be where appropriate is the language, right? And then there's guidance from 2022 from the federal agencies that clarifies that should almost never happen, right? Because they recognize, right, the level of harm that's happening. I know there have been some suggested potential amendments from some testimony, right? I view those as friendly ideas personally, right, in terms of if they were going to add more clarifications. But this language is the exact language from the department bill last year, and I support it strongly. Thank you.
Christopher Dews, representing again the Center for Urban Families. I do want to thank Delegate Simpson for sponsoring. I want to thank Professor Hatcher and even the department more so for supporting this piece of legislation. Me too.
Those are the words I've been waiting to hear for so long. Okay, great. And I will ask you, Delegate Simpson, based on the unfavorable testimony from Judiciary, are you in the process of working with them? I heard Mr. Hatcher say that some of the amendments may be actually favorable. I don't know if that was one of them that, if theirs is one of them that you might consider, or is it just the Office of the Public Defender?
I did speak with them last week about this particular bill, and of course their concern was, well, what if you have, parents who are making a great deal of money, and are we really not going to pursue that? And said they weren't sure if they were going to have enough time to be able to actually put together an amendment. So I will follow up with them. Interesting enough, for both the Office of the Public Defender and Judiciary, the issue really is actually what you had said, is when is it appropriate? And as we said, it seems with the federal law that it is very clear it is almost never appropriate, and it is never actually cost effective to collect. So, that's kind of where we are as far as this is the exact same language. It does say that it limits, it really doesn't identify when it is appropriate. And like I said, the federal government literally said it wasn't. I do kind of feel like when I spoke to the Judiciary, it is one of these things of, it's kind of hard to turn corners, really is what it comes down to. I'm not really aware of a whole bunch of families that have a lot of money that then their kids are in foster care.
Okay, great. Members, do you have any questions? Delegate McComas.
I'm not going to dispute that most of the folks probably are low income, that kids are in foster care. But we always used to play in this committee, oh, well, what if you had this? I'm not going to play that game, but I am going to say that what happens if you do have somebody that's well off and they're just nasty people and the kids don't get along with them? And so I think there should be something there that, and you guys can figure out what that number is. If it's a certain number and then above, then they should have to pay back.
I can tell you from when I was a Child Protective Services worker that there were a couple cases, and they usually were either sexual abuse or physical abuse, and that sometimes by pursuing this with these families, you ended up them wanting the child back or the reunification when actually that was not in the best interest of the child. So I can tell you the few cases that I know of that I actually had experience with, in some ways it was better to be able to allow that child to move into a safer environment. It was not a family that wanted the child until the child support was pursued. And then suddenly they were interested in some type of reunification.
Well, I guess, okay, so basically, if you push for the money, then it's all about the money, and they want the kid back. But if you don't push the money, they can go to foster. You guys are going to have to figure out what's the best, or have it on the books, and then you walk away and say, okay, we'll keep the kid, we won't. But I think there should be something there, because it's not fair to the rest of society that they've got money and the rest of the taxpayers are paying.
Once again, the federal, where they came from is that if we go down that lane, we will have to make that assessment on every single one of the families, and that's where the cost goes, and you only are going to have a certain number.
You have to do it.
You would end up having to do it.
You can't have a state law that says, okay, if they make over X amount of money.
But you'd have to find out how much they made in order to make that. The department would end up having to make an assessment on every single one of those cases. And I think this is why they support it, that there would be so few times, why would we be putting the resources into them to figure that out?
So you're saying there's no way that if the kid goes in foster care, you don't know what the assets are of the parents that the kids go into foster care?
It would have to go into, but once again, the way it is written, it does not prohibit. I think that's why they DHS likes it being a little ambiguous, is because it does not prohibit them pursuing.
Okay.
But it does not state that they have to. So then the state is not paying the costs in order to pursue this, and families that it definitely knows it would be much more expensive. Does that?
It sounds like we're blurring the lines, but that's okay. If it works, it works.
If I could add just one clarification as well. I also think I agree with the comments that it doesn't take away the agency discretion if that rare circumstance happens, which doesn't happen, right? You know, like but in case it did, that would be the ability of the agency to decide they wanted to pursue child support. It also doesn't take away the court's discretion if the agency doesn't act. Even if an agency doesn't make a decision, that non-decision is reviewable by a court as well under administrative law principles. So the court could still move forward as well, but it doesn't have, like in almost all of the cases where child support is initiated against families who are pulled into the foster care system, the child support is virtually non-collectible because everybody's low income. So it's just nonsense. Like it's causing harm, like across the board.
No, I understand that. I guess it's just, I'm just saying if you have high rollers and they're really nasty, and there are people like that.
Sure. Yeah. And that they wouldn't fall through the cracks, or they wouldn't have to. The agency could catch it, or the courts could.
So you feel that the ambiguity, because if they're high rollers, they got lawyers, okay? So the question is, if you have the ambiguity, you think you could still get the money if the department wanted it?
Under the bill, yes.
Okay, and if they don't, then I guess you could tell us, you could let us know. I just think it should be kind of clear, but that's okay. I mean, I understand. You guys know better than I do.
Okay, well, thank you very much, Dahlia, for bringing the bill. And I believe that, well, we have someone online.
We have favorable amendments.
Just one second. Yes, Haley Lichterman, favorable with amendment.
Thank you, Madam Chair and members of the committee. My name is Haley Lichterman. I'm the Deputy Chief of the Parental Defense Division at the Office of the Public Defender. For all the reasons stated by the panel, the Public Defender's Office would ask for a favorable report of this bill, but would ask for the following amendments, and hopefully that would help alleviate some of the concerns that were listed by both the judiciary and some of the questions that just came before the panel just now. So me too, as to why we support it. I'm going to move on and just talk about the amendments that we're requesting. First of all, the amendments go into portions of the statute in the courts and judicial proceedings to make consistency between the different parts of the law so there isn't any confusion. But also, the Public Defender's Office agrees that limited circumstances is unfortunately too vague. We're afraid that leaving that language just opens up a lot of litigation because you could have an entire hearing as to the court having to make a finding of whether or not this counts as a limited circumstance. And while the federal government issued guidance, which is in the form of a letter that describes what the limited circumstances are, what we actually did was put suggested amendments into the bill that say when a person is what's called indigent, which is impoverished, that they should not be filing for child support in those situations, that the case should always be heard with the SINA case. Right now, it's up to the discretion of the two different courts to communicate. It adds a lot of delay and it adds a lot of issues. Having the case heard with the SINA court allows the court to decide what's in the best interest of this child. The child has their own attorney. The parent has their own attorney, even if they're impoverished. And addressing the concern of Delegate McComas just now, our office represents approximately 95% of those who are faced with a SINA or a TPR case, which means that at least 95% of the parents are under the federal poverty guidelines. These are not people that the department should be seeking child support from. Those are the exact people that we're here to talk about, where the government's spending more money going after them for child support than what they're actually collecting. And so actually I'm happy to answer any questions about the amendments. The amendments are listed on the last page of OPD's testimony.
Thank you. Members, any questions? Seeing none, that concludes our last bill hearing for the day, House Bill 324. We are adjourned.
Thank you, Madam Chair.